Start the recording. Let's start with the roll call. Chair Shearer is here. Vice Chair Wallen.
Here.
Commissioner Langton.
Here.
Commissioner Lowry.
Here.
Commissioner Miller. Here. Commissioner Moran. Here. Commissioner Reynolds.
Here.
Smith.
Here.
Staff, Executive Director Armstrong.
Here.
Commission Counsel Bassett.
Here.
Investigator Terry.
Here, but not here.
Acting Associate Counsel Hazlett. Senior Legal Researcher Pani.
Here.
Outreach and Education Officer Harvey.
Here.
And Executive Assistant Saldana.
Here.
Okay, would you please join me in the pledge of allegiance? Pledge allegiance to the flag.
Good night. Thanks, America. And to the republic for which it stands. One nation.
This will liberty and justice for all. Thank you. Brings us to item 2 on our agenda, which is public comment. Is there anyone present here in Las Vegas today who would like to make public comment? Seeing none, is there anyone on Zoom who'd like to make public comment?
No, there was no one that wanted to provide public comment.
Executive Director Armstrong, have you received any public comment by email to be read into the record?
We did, and I will read it into the record now. My name is Brian Dufferin. I served on the Nevada Commission on Ethics from October 2016 to October 2023. My public comment is related to item number 10 on your agenda today, the recognition and the honoring of Commissioner Teresa Lowry's service to the Commission. I also wanted to acknowledge her service to the state of Nevada and her dedication in serving on the Commission. When I served on the Commission, I valued Commissioner Lowry's experience, wisdom, and expertise she shared with me and the entire Commission. Her insights and understanding of the ethics law were refreshing and valuable when confronted with cases that were unique and complicated. She understood that the rule of law mattered. I always knew Commissioner Lowry was prepared for each meeting, exemplified by her no-nonsense comments, questions, and voting record. Commissioner Lowry was a perfect example of the Ethics Commission's guiding principle number 1, to protect the citizens of Nevada by interpreting and enforcing the provisions of the ethics law in a fair, consistent, and impartial manner. As an ethics commissioner, it is of the utmost importance to stay true to your mission and your guiding principles, and I witnessed Commissioner Lowry doing just that. Her high level of integrity was impressive. All former commissioners leave a legacy that shapes the future direction and reputation of this important institution. Commissioner Lowry can be proud of her dedicated and invaluable service to the Commission and the state of Nevada. Finally, I want to thank her for making my time on the Commission rewarding, and I wish her all the best in her future endeavors. Thank you, Brian Dufferin.
Thank you. Any other public comment that we received by email or needs to be read into the record?
That was the only public comment received.
Okay, it's item number 3, approval of the minutes of January 21, 2026 commission meeting. As everyone should have had minutes in their materials. Anyone have any changes to the minutes or questions about the minutes? If not, do we have a motion to approve the minutes?
Move to approve.
Moved by Vice Chair Wallen. Do we have a second?
Second.
By Commissioner Lowry. All in favor, please say aye.
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 Opposed? Hearing none, the minutes are approved unanimously. Next item is item number 4, discussion and possible approval of a proposed stipulated agreement concerning ethics complaint number 25-136C regarding Jesse Whipple, Mayor, City of Mesquite, State of Nevada. Vice Chair Wallen and Commissioners Reynolds and Smith served on the review panel for this matter and are precluded from participating in any further proceedings pursuant to NRS 281A.22074. Do we have counsel for Mr. Whipple or Mr. Whipple himself present?
I'm here.
Great, thank you. Executive Director Armstrong, would you please provide us with your presentation on this matter?
Thank you, Mr. Chair. On July 24th, 2025, the Commission received an ethics complaint regarding Mayor Whipple. Mayor Whipple had a long-standing pest services agreement with the City of Mesquite. Upon becoming mayor, that agreement was not reevaluated, and those services to the city continued with payments from the city to Mr. Whipple's company. And multiple occasions, Mr. Whipple did not do a proper disclosure from his position as mayor and city council meetings as they were approving invoices in that matter. It's important, I think, for the commission to know that the Mesquite form of city government, the mayor does not vote on these items, so he's not voting to approve them, but he did not disclose during the presentations. And so, those services continued and he received financial gain from those contracts. The agreement, after the review panel referred the case, the parties agreed to go to a settlement conference, which resulted in the agreement that we bring before you today. This agreement includes a single violation of NRS 281A 420 subsection 1, which is our disclosure rule. And specifically, we're asking the commission to conclude that the failure to properly disclose his interest in Got Bugs, which is the name of the company, each and every time payments were heard by the council, establishes the violation. The other violations that were at issue are dismissed by the parties. The parties agree that this single violation will be considered willful based on the factors in the agreement, including the repeated nature of the failure to disclose the interests and the ongoing not evaluating the ongoing relationship. As part of this agreement, Mayor Whipple agrees to successfully complete ethics law training within 60 days of approval of this agreement, and this stipulation will serve as an admonishment under the ethics law as well. That is the basics of this one. I want to thank Mayor Whipple, who was cooperative throughout the process. And I want to thank Commissioner Smith for running the settlement conference and helping us get to an agreement in this matter. And with that, I'll take any questions.
Any questions for Executive Director Armstrong on this matter? Seeing none, Mr. Whipple, do you have any comments you would like to make?
My only comment is I just want to thank the commission and those that helped me with the settlement conference. Everybody was great, respectful, helpful, and I learned a lot. Part of my problem in this was my ignorance, and the commission was very helpful in educating me, and I really appreciate, all involved. Everybody was very professional and helpful. Thank you.
Great, thank you for those comments. If there are no other questions, do we have a motion? I'm sorry, you have a question?
Not question.
Or comment?
Comments?
Yes, please.
Thank you, Chair. I just want to briefly explain what's going to be my no vote. Typically, there would be a fine in a case like this, and the fine would be up to the amount that the company made, which would have been $6,600. The reason for my no vote, because there is no fine, is because what I consider the aggravating circumstances to be that the acknowledgement that Mr. Whipple knew that the contract for his company was on the consent agenda, and that there were multiple votes regarding the company and the contract. Additionally, Mesquite's counsel advised the mayor to seek an advisory opinion from the Ethics Commission because of the conflict, and he chose not to seek an advisory opinion, which is not an onerous process, doesn't cost anything. You can reach out, and our commission counsel gets those done and turned around very quickly. So for those reasons, I'm going to vote no on this negotiation. Thank you.
Any other questions or comments from commissioners? I just have one question. There was something in the materials that indicated that Mr. Whipple's business was performing these services at a below market rate. Is that accurate, or is that something you looked at?
We did not do like a full market analysis, but the invoices that we saw seemed reasonable for those services. And it didn't change when he became mayor. It's not like he was charging one rate and became mayor and all of a sudden he's getting double that rate.
and I guess I'll just say, I appreciate your comments, Commissioner Lowry. But based on that, I'm comfortable with there not being a fine in this particular case, so I plan to support this stipulation. With that, I'll ask if there's a motion on the stipulation.
I'll make a motion to approve it.
Moved by Commissioner Miller. Do we have a second?
I'll second it. Mike
Second by
Langton.
Commissioner Langton. All in favor, please say aye. Aye.
Aye.
And noes?
No,
So we have one no. Commissioner Lowry. Anyone else wants to be a no, please make sure you speak up so we can record you appropriately. Otherwise, it's passes with just the one no vote. That brings us to item number 5. Discussion and possible approval of proposed stipulated agreement concerning ethics complaint number 25-157C regarding William Gardner, former Deputy Administrator, Chief Administrative Officer, Department of Business and Industry, Division of Industrial Relations, State of Nevada. Myself and Commissioners Lowry and Moran served on the review panel for this matter and are therefore precluded from participating in any further proceedings pursuant to NRS 281A.220 sub 4. So Vice Chair Wallen will therefore preside over this matter.
Thank you. At this time, I would like to ask councils for the parties to introduce themselves. Do we have a counsel for Mr. Gardner?
Yes, Commissioner, this is Bill Peterson from the firm of Snell and Wilmer. I'm here on behalf of my client, Mr. Gardner.
Thank you.
And Ross Armstrong, Executive Director, presenting today.
Okay, Executive Director Armstrong, please give us your presentation.
Thank you, Madam Vice Chair. On August 26, 2025, the Commission received an ethics complaint alleging a violation of the ethics law's cooling off provisions in 281A 550. The Commission completed its investigation and a review panel determined that the facts established credible evidence to support a determination that just and sufficient cause existed for the Commission to render an opinion. Included in the panel recommendation were some notes from the panelists about some of their thoughts on the facts of the case. They wished the Commission to take into consideration and myself to take into consideration when determining a resolution in this case. As we noted, Gardner served as the Chief Administrative Officer for the Nevada Occupational Safety and Health Administration, OSHA. His last day in the office was in late July of 2025. His last official day at the office was August 26th, 2025. Within the 1-year prohibited time, he went to work for the Penta Building Group, which I'll just call Penta, which triggered the cooling off prohibitions based on his job duties while he was at OSHA. The agreement that we have entered into this matter, which we did without a settlement conference. So I appreciate Mr. Peterson coming together with me and being able to come to a resolution without a formal settlement conference. But the proposed resolution today is that Gardner's course of conduct results in a single non-willful violation of NRS 281A 550. Some of the reasons why we thought it was appropriate for this to be non-willful is that the worst case scenario in a cooling off case is you have a public officer, they're approached by an agency that is regulated, and that public officer does something for them prior to their departure in exchange for future employment, right? That's our worst case set of facts. But this was nowhere near that. So Mr. Gardner had his last day and then went home and sought to find a new employment. So there was no pre-departure discussion with Penta about employment before Mr. Gardner left OSHA. Mr. Gardner has no previous history of the ethics law, and there were lots of factors in the statute that in favor. Like, so also in our cooling off laws, you can ask for relief. And when taking a look at this case, the panel in their determination noted this too, like there are lots of facts in Mr. Gardner's case that would meet those probably had he asked for an advisory opinion before he left. So if that departure was planned out in advance and he asked for that, there are lots of factors that lean towards potentially granting relief, including that the part in 550 is that it's a regulated industry. Well, OSHA regulates just about every single workplace, and so there's a very broad scope there for the agency. And then the nature of the departure and the timing would lean towards allowing for relief in the case. So this really is a kind of a technical timing, totality of the circumstances issue, why we agree that it should be a non-willful violation. The requirements, the stipulated agreement includes that Gardner will not consult or lobby Nevada OSHA on any matter for Penta for 1 year from his departure from OSHA, which is a stricter prohibition than is in the ethics law. So he's agreeing to a stricter prohibition for the remaining 1 year of his time since departing. And he will complete cooling off training through our online training system. And then we're also going to be providing him a packet of cooling off resources that he has agreed to send to Penta's Human Resources Office, so that if they have questions about hiring former public officials in the future, they know what those rules are and what needs to happen before actually engaging in that employment conversation. So that is the recommendation today, the non-willful violation of 281A 550, and the two, or I guess that's kind of three conditions on Mr. Gardner. And I'm happy to pass it over to Mr. Peterson if he has any comments or take any questions.
Not really. I joined the comments that I heard, excuse me, from Mayor Whipple. I thought that Mr. Armstrong handled this in a very judicious manner, very thoughtful manner. This was an unusual situation. Mr. Gardner, as Mr. Armstrong pointed out, did not engage in any pre-termination activity or solicitation of employment. He was in fact terminated. He has two small kids. He had to make a living. Mr. Armstrong pointed out, OSHA regulates virtually every business in the state of Nevada. This is kind of a catch-22 in the statutes, where basically he would be prohibited from employment anywhere in the state because OSHA regulates everybody. There was certainly no premeditation here, no intent to violate the law. This is just a working guy, needed to support his family, was terminated, got a job. There couldn't be really, in my view, any more reason for the Ethics Commission to discourage this kind of employment, because his interests are perfectly in line with the commission. He's employed as a safety officer. He's there basically to promote, implement the policies of the state in this large construction company. And basically it's something I think that the Ethics Commission should be pleased about more than anything else. Certainly no mens rea here on behalf of Mr. Gardner. He's just a hardworking guy trying to make a living, faced with unfortunate circumstances, did not solicit employment and went to work.
Okay. Thank you, Mr. Peterson. Appreciate it. Commissioners, questions for either commission executive director or this council?
I'll note that we caught one just error in a date on page 4 in paragraph E. That'll correct before we issue it, but it's not substantive.
Right. Not seeing any other questions, I'll entertain a motion to accept the terms of the proposed stipulated agreement and direct commission counsel to finalize the agreement in appropriate legal form.
This is Mike Langton. I'll move to accept the terms of the stipulated agreement as presented by the parties.
I'll second that agreement.
All
Motion, excuse me.
Okay. All those in favor say aye. Aye.
Aye.
Opposed? Motion carries. Mr. Peterson, thank you so much for working with the commission and with your clients with the commission. We really appreciate it.
I appreciate you very much. Thank you. I'm going to sign off now.
Thank you.
Bringing us to item 6, discussion and possible approval of a proposed stipulated agreement concerning ethics complaint number 25-159C regarding Rudy Pamantuan, Chief of Staff, Lieutenant Governor's Office, State of Nevada, Vice Chair Wallen and Commissioners Reynolds and Smith served on the review panel for this matter and are precluded from participating in any further proceedings pursuant to NRS 281A.220 subsection 4. Do we have counsel or Mr. Palantuan here?
Good morning. My name's Gus Flangus. Myself and Kimberly Stein are present here on Zoom on behalf of Mr. Panatuan.
Great, thank you. Welcome.
Thank you.
Executive Director Armstrong, please provide us with your presentation on this matter.
Thank you, Mr. Chair. On September 9th, 2025, the Commission initiated this ethics complaint alleging violations of 281A 402 and 7. The subject Palantuan provided a timely response. A review panel determined that there was just and sufficient cause to refer both 402 and 7 to the full commission. Following that, the parties engaged in a settlement conference overseen by Commissioner Smith, and we've come to this agreement that we bring before you today. The key facts is that while serving as Chief of Staff, Mr. Palantuan served as the treasurer of Pioneer Technology and Arts Academy, a nonprofit educational management organization in Nevada. That he used some of his government time, staff, and equipment to work on those matters, including a visit from Secretary of Education Linda McMahon. In addition, the investigation revealed some use of state emails for personal items. And the agreement that we are entering into today is that Mr. Palantuan stipulates that his conduct constitutes one non-willful violation of the ethics law, specifically 281A 400 subsection 7, which prohibits the use of government time, property, and equipment or other facility to benefit a significant personal or pecuniary interest. The alleged violations of NRS 281A 400 subsection 2 are hereby dismissed. There are factors in the stipulation about the finding of the one non-willful violation. As part of the agreement, Palantuan agrees to pay the civil penalty of $1,000 pursuant to NRS 281A 793 within 1 year of the approval of the agreement, with any sort of payment plan that I may establish as the executive director. He also agrees to complete ethics training as approved by the executive director within 60 days, and pursuant to 281A 785 2A, the commission would hereby admonish Palantuan that he must refrain from using his state email systems for private business. And that is the agreement. I'm at this time, I'm happy to answer any questions.
Mr. Flangus, any comments that you'd like to make?
Just very quickly, thank you very much. I just want to say we appreciate all the work that went into getting this stipulation done on both sides. It was a little bit of a contested matter, but we were able to resolve this issue. And I think that the result of this is fair to everybody involved, and would urge that y'all approve it. Thank you.
Thank you. Commissioners, any questions or comments on the stipulation? For Mr. Flangus or Executive Director Armstrong? Seeing none, do we have a motion to approve the stipulation?
I'll move to accept the terms of the proposed stipulated agreement and direct the commission council to finalize the agreement.
Moved by Commissioner Miller. Do we have a second?
I'll second it.
Seconded by Commissioner Langdon. All in favor, please say aye.
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 Any opposed? Passes unanimously. Thank you, Mr. Flangus.
Yeah, and thank you. Just one other quick item. Ms. Stein and I are appearing for Lieutenant Governor Stavros Anthony today, and the notice said that arguments would probably be heard at 1:30 today. I just want to verify that, because if it's earlier, we'll come on down right now.
I mean, it potentially could be earlier. Things seem to be moving a little quicker than we anticipated. So it may be earlier. If you could come down a little earlier, that would be great.
All right. Well, thank you very much. Appreciate it.
Appreciate you.
Just and I can't participate now because I was on the review panel, but just if we could give Mr. Flangus time. Are you planning still to take a lunch break, or do you plan to move straight through?
Well, I think if Mr. Flangus is here by 1, that would be
Yeah,
fine.
1 would be great.
All right. Thank you.
Thank you.
Thank you. That brings us to item number 7. Discussion and possible approval of a proposed stipulated deferral and dismissal agreement concerning ethics complaint number 23-035C regarding Jim Seebach, Deputy Chief of Police, Las Vegas Metropolitan Police Department, State of Nevada. Commissioner Lowry served on the review panel for this matter and is precluded from participating in further proceedings pursuant to NRS 281A.220 sub 4.
I should also note, I'm conflicted from this matter because I served as the associate counsel when it was brought before the commission initially. And so we have Deputy Attorney Ravencroft here to provide legal counsel.
Great, thank you for being here. We appreciate you. And do we have counsel for Mr. Seebach here?
Yeah.
No
Yes,
joke.
thank you, Chair. Samuel Merkovich on behalf of Councilman Seebach.
Great, thank you. And Executive Director Armstrong.
Yes, you ready for my presentation?
Please.
Okay, on March 2nd, 2023, the commission received this ethics complaint regarding Mr. Seebach at the time, he was Deputy Chief of Police for Metro running for City Council. The allegations of that complaint included the use of his law enforcement equipment in advertising for his campaign. The commission investigated it. A referral was made by the review panel, and then we had a number of law enforcement uniform cases that were going on at the same time and were being litigated on appeal. And so the parties agreed to a stay pending the result of that litigation in both the Lombardo matter and the Rodriguez matter. And so with those two matters out or completed with litigation, we are proceeding now with this agreement. For those of you that recall the Rodriguez agreement, which was somewhat similar conduct, this is very similar to how we resolved that particular matter, which is a stipulated deferral agreement, finding that the terms were satisfied and immediate dismissal of the case. So in terms of that agreement, we note that there's deferral period for 2 years, starting from December 21st, 2023 to the present, where Mr. Seebach was required not to be the subject of another ethics complaint that was referred by a review panel. Mr. Seebach has not been the subject of another ethics complaint that has been referred by a review panel, so he's met that requirement. In addition, he agrees to take ethics training within 60 days of approval of this agreement. And we'll note that Mr. Seebach has had some questions regarding the ethics law since this first case, and has been diligent along with his counsel in reaching out for educational materials and perspectives to maintain compliance. So what we would expect hopefully out of all of our deferral agreement folks is that there's a commitment to following the law and folks reaching out. So noting that, the parties now agree that the violations of the case, specifically the violations of 402 and 7, at this time be dismissed, and that this agreement be the full and final resolution of the matter.
Mr. Merkovich, any comments?
Thank you, Chair. Just briefly, I think the finding here that of no violation is absolutely the right one. Beyond that, I want to thank Commission Counsel Bassett, Executive Director Armstrong for their professionalism. It is a pleasure working with them. And on behalf of Councilman Seebach, I want to thank the Commission for its time today in hearing this stipulated resolution.
Thank you. Commissioners, any questions or comments for either Executive Director Armstrong or Mr. Merkovich on this matter?
Yes, Langton. Director Armstrong, in the stipulated agreement on page 2, item 2D, you said he had his willingness to seek advisory opinions. My question is, during that time, you said he sought questions. Did he seek advisory opinions?
No, he sought an advisory opinion from us.
Okay, yes.
Okay. All right, thank you.
Any other questions
I have none.
and comments? Do we have a motion to approve the proposed stipulation?
I move to accept the terms of the proposed stipulated agreement and direct commission council to finalize the agreement in appropriate legal form.
I'll
Moved by-
second the motion.
Seconded by Commissioner Reynolds.
Correct.
Any other discussion on the motion? Seeing none, all in favor, please say aye.
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 Any opposed? Seeing none, that is adopted unanimously. Thank you, Mr. Merkovich.
Thank you.
Thank you, everyone. Bye-bye.
Brings us to item number 8, review of report from the Commission's Legislative Committee, discussion and possible approval and direction for the Executive Director to proceed with the bill draft request process consistent with Commission determinations. Vice Chair Wallen, can you please?
Thank you. Thank you. Appreciate it. So we've met several times, right? And what you have before you is our final version. Since we met in February, February meeting. The major changes that we've had on here is in the gift area and in the cooling off. And in the training, we changed it from mandatory training of each public officer from 30 days to 60 days. I noted Chair Scheer said he would like to see us change that to 90 days because of the legislature. So I'm good with that. Okay. Other proposals in here talking about the cooling off and lobbying. The big change is we've changed it down here to person upon any issue before the agency and before which was under consideration. It's just any issue before the agency. You cannot lobby for 1 year after you leave public service. We've expanded confidentiality. We went through that at our previous meeting. And then other things, we have unwarranted harm, impropriety. There's no change since our previous meeting there. And then we get down into gifts, and this is where we did a lot of work in gifts. It was a long conversation, but I thought, we finally reached some good conclusions. We have defined what a gift is. It complies with our other NRS that is 281.455. I was trying to find it.
Yes, 281.455,
I believe. So we didn't want to have a different definition of gifts from what was in another statute. That just doesn't make sense, even though that ours is better. We put in here things that what is not a gift, like items of food and refreshments, greeting cards, plaques, certificates, loans from banks, other financial institutions, opportunities in business and benefits, including favorable rates, commercial discounts, and rewards and prizes given to competitors in contests or events, including random drawings open to the public. So that was one thing that we did there. And then we went into talking about when determining a gift, if the commission is going to have a case before them, what would they look at in determining it, the gift? It is a gift. And one big thing, would it tend to improperly influence a reasonable person? Okay. Whether the giver of the gift is an individual with substantial interest in the legislative, administrative, or other governmental action of the public officer or employee, the value of the gift, the ability of the officer to make official decisions regarding individual or entity providing the gift, relationship between the giver and the public officer, the language used in the seeking of the gift by the public officer or employee means if they go, hey, will you give me this and I'll do this for you. So we look at that. Whether the event provides primarily educational information. If you go to an event, it's educational, that's not a gift. If your attendance at an event is clearly for ceremonial purposes, and the extent to which the event attendance offered to the public officer or employee is broadly available to the general public. And then we also added factors that we would look at in consideration of whether or not this would be a violation or not, so. That, I'll entertain any questions. Or if my fellow commissioners on the subcommittee want to add anything to that, please do so.
Questions or comments from commissioners? I'll note that I suggested the 90 days just because technically under the Nevada Constitution, a legislator takes office right after they're elected. And they do training, ethics training for new legislators at their new legislator orientation, which usually takes place in January before the legislature convenes, but that may or may not be right around 60 days, so about 90 would give them the opportunity to make sure that they weren't in violation of that 60-day requirement. Was the reason I suggested that. With regard to the gifts, I have a question of what was intended. I am aware of some conferences, for example, where the certain public officials will be asked to speak at the conference, and in return, they will receive free entry to any of to the entire conference, so they don't have to just come to the one they're speaking at. And there's usually some kind of small speaker gift, usually in the less than $100 range, but those gifts are given to all of the speakers, and that attendance or free attendance is extended to all of the speakers. I guess I'm just wondering how that would apply. It's not, the public officials are not singled out. They're not given something the other speakers are not given. But
Yeah, that's a great question. And in our honorarium prohibition in our law, we have specific, like, if you're asked to come speak at something, the reasonable costs of having you there, that's not an issue. In this one, I would say that plaque or gift that they're given for speaking would fall under exception 2, under the definition of a gift, greeting cards and items with little like intrinsic value, plaques, certificates, trophies, which are intended primarily for like the presentation, like thank you for your item. And then in terms of determining whether that is going to be a 401, I think you could look at all of the factors that are established and say that's likely going to be not an issue. If every speaker gets a Ferrari, there might be an issue, right? But if it's a plaque or a stress ball or a little thank you, it's not going to be.
Yeah, it might be like a charge. I mean, I remember I know one year they gave out these multi-device chargers or a battery,
Right.
Travel batteries, travel batteries, those kinds of things. Usually with the organization's logo on it, but.
Yeah, we have one in our lobby from the code compliance folks down here, and we go once a year. They have a little plaque that's, thank you for sharing stuff.
Yeah, this is, I'd like to comment on this, Terry Reynolds. I concur with the executive director's comments on that. When I was at Business and Industry, we would allow, have the reasonable cost of attendance at a conference that a person was speaking at or on a panel for a particular subject. We allowed that, but we did not allow any financial honorarium on top of that. So, and that was a specific policy that we had within Business and Industry. And I know several of the departments also have that prohibition in terms of financial honorariums. Now, small gifts in terms of how that was indicated by the executive director would not be considered a financial honorarium on that, would be okay. But I just wanted to clarify that, because most departments do not, within the state and through the direction of the governor's office, do not allow financial honorariums for speaking at conferences or being a subject expert at a conference.
Isn't it, I thought with honorariums, it's like if you're speaking in your official capacity, you cannot receive an honorarium.
Right, it's very specific. It's a pretty narrow prohibition.
Yeah, but if you're there speaking as an expert on whatever, like when I went and spoke and I got an honorarium, but I was speaking as being a CPA, CMA, and a member of this organization, that's how I got the contact. But I still donated the money anyways, just to be safe. Yeah, so. Yeah, you're correct, Commissioner Reynolds. It's very specific about accepting honorariums.
Yes.
Thank you. Any other comments or questions?
I just want to say, I want to thank, like Commissioner Reynolds, who is the vice chair of the subcommittee, and I want to thank Commissioner Miller for their participation in this subcommittee. I think that we came out with a very good product and had a great exchange of ideas, and I really appreciate their input on it. So thank you very much.
Thank you.
With that, do we have a motion to ask the executive director to proceed with the bill draft request?
I will move that we direct the executive director to proceed with the bill draft request process consistent with the commission's direction. I would include the amendment of the training from 60 days to 90 days as presented by Chair Scheer.
We have a second to that motion,
I'll second it.
seconded by Commissioner Langton. Do we have any other discussion on the motion? Hearing none, all in favor, please say aye.
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 Any opposed? It passes unanimously. Bringing us to item number 9, review, discussion, and possible approval of budget priorities for consideration during the 2027 legislative session and direction for the executive director to proceed with the budget building process consistent with commission determination. Executive Director Armstrong, will you please provide us with your presentation on this item?
Yes, thank you. There's materials in your packet, and I want quite a number of commissioners who were not here during the last time, and so I want to talk a little bit about the process so that that's clear, and then talk about the priorities that we're looking at as a staff recommendation. So we had the budget kickoff a couple weeks ago, where all agencies get basically their marching orders to quickly get everything done and submit the requests. At that time, you'll typically learn if agencies are being requested to build budgets that cut funds or maintain flat, or if there's increases. Typically, the budget build includes what they call a 2 times cap. You take 2 times one of your years for your next 2 years. And then enhancements you want go into a bucket called items for special consideration, where all the agencies fight for whatever extra money there may be. And so that we are in that process now. The way the commission has handled that in the past is, because it gets very technical, is to provide me with the agreed upon priorities, and then we work with our administrative services division team to get that budget built and submitted and all of that. And so the overarching process is we're in this build area. We submit it to the governor's office. The governor's office will review it. The governor will then, right before the legislative session starts, release his or her recommended budget, and then we'll go to the legislative session. This is interesting in years where there's an election, because most of the bulk of the budget is built, and then there's going to be decisions for whoever wins the election. Then we go to the legislature, and it's basically a 3-step process. One, we go to a budget hearing. So I show up, typically the chair and vice chair will also show up, and we present why our commission is so great and the things we're asking for. And then there's a hearing where they don't ask our opinion, they just make decisions about what's going to happen, and that's budget closing time. And then it gets all wrapped up into the Appropriations Act, and we find out what we get. And so, like I said, we're in the agency build portion, and on the second page, you can see some budget enhancement priorities. I will disclose that obviously I have a pecuniary interest in the level of my salary and location of the office, and so I will disclose that prior to presenting this information to you. We came up with essentially 4 priorities for budget enhancements. Our last major budget enhancement was a replacement of our case management system, which is almost at the place we're going to pick a provider and proceed with that process. The one before that was the addition of our outreach and education officer. We now have Sam doing an excellent job in that role. That was an obvious hole for us. As part of our strategic plan, but we did some time studies in the office and tried to look like, is there one big chunk of stuff that makes sense for a SAM or something else? There really wasn't like an obvious one thing we need, but we do know we need capacity. We've had growth in the number of our cases consistently since COVID ended. The start of this year has been wild, as you all know, for your jurisdictional recommendations and Commission Counsel Bassett's advisory opinion list continues to grow, which for me, I think, and I say this when I go to training, I say it would be amazing if we had a year where we had more advisory opinions than investigations, because that means people are being proactive and they're out there asking for help and those types of, and we may hit that this particular fiscal year. And so we took a look at the office structure and what needed to be done. We think that asking for an administrative assistant 3 position, a full-time position, who would really work to serve Commission Counsel Bassett and our Regional Education Officer Harvey. Public records requests, we're getting more and more public records requests. Those have strict timeframes in the statute. There's lots of review, redaction, intense administrative items. Assistance to help specifically with advisory opinions. They're very different beasts than our investigations or managing our finances or those types of things. And the other thing that it would do too is currently when we have a contested case, the executive director side that is prosecuting the case loses their paralegal because the paralegal is helping the commission counsel. So this would allow Liz to have administrative support to issue orders and those types of things and maintain paralegal support for the actual prosecution of the case. So that is the ask for the administrative assistant 3 position. The way that it works is you basically tell them what you want. It may be a 3, it may be a 2, it may be a 4. You don't really get to pick, but they allocate the funding for that. Under each of these enhancements, you'll see some numbers, and then you'll see our strategic focus. One of the ways I found to be successful in your budget building and what they ask you to do is to align it to the governor's strategic priorities and then make sure it's aligned to your own strategic plan. So that tells you which part of the governor's strategic priorities, based on the nature of our agency, most of those are in the 5 category, which is good public service from state agencies. So that first one is that administrative assistant 3 position we would seek. The next one is an office relocation. I think our preference would be to relocate to Reno for recruitment and retention purposes. Each time we've opened up hiring in the last couple of years, there's not folks applying from Carson in a lot of those areas. And then also we just need a better office. One of the things, if you've been to the office, you know, Investigator Terry, who, can you make sure he's done to get lunch? And Investigator Terry, he sits at the end of a conference room table. And in the past, he'd like hop in his car and go interview people, but now post-COVID, that's all done by Zoom. And so he needs an office, right? We don't have an office for our investigator where he can close the door and have a private an actual investigation interview with someone that they can have confidence it's in private and that he can assure that too. So that's one of the things we may be looking at options prior to the session with the leasing services for that one, but that is one of the things. We're such a small agency, like big agencies can kind of move, they got money to move. Like us, the big costs include like the actual movers and those types of things. We don't have that in our budget. So that is a thing we would like to pursue. The other one is, if you remember Paul from last summer, who was doing great at ASU Law School. Now, we had a summer legal intern, Paul, last year, and we were able to do it because there was a vacancy in one of the positions. I think it was the vacancy in the senior legal researcher position. So we had category 1 personnel money to do that. We have 0 vacancies now, and so we can't just pay someone to be a summer intern. But we found that to be beneficial in a couple ways. One, it allows us to build long-term a workforce, hopefully, of Nevada attorneys who understand the ethics law more than most out there, right? So say Paul comes back and he doesn't come to work for us after law school, but he goes and he works in any industry. He'll know more about the ethics law and can help people comply with the law that way. And it also will develop career pathways, right? He now has a better experience of understanding that there's this area of the law that is state service and government service. And so I've always reviewed, especially retention, like if we can keep people in state service, in public service, that's a retention win for us. And so the amount of funding for that, I had to do the math, it's about 0.1 full-time equivalent. It's about $10,000 to $12,000 maybe for that particular program. And then the last one, and this one typically is not a decision unit that we build into our budget, but that has occurred before and has been helpful. And I believe Vice Chair Wallen has gone to the table before and written a letter of support, just general state employee compensation and benefits, right? Like, we're not asking for special increases for commission staff. We've attempted that before and not been, before my time, we've attempted that before, we're not successful. But there's generally a pretty big gap between our state attorneys and state agencies and local governments. And so it can always be helpful to have a message from the commission that says, if there's a general thought of increasing salary and compensation or benefits for state employees, that there's support from that among the commission. So that's what we developed, not huge, gigantic asks, but we found that if we're very specific and can align our asks to the needs of our agency and show our work about why we need those, that those are successful. So I'll submit those for your consideration, and I'm happy to answer any questions that you may have.
Questions for Executive Director Armstrong?
No, I remember supporting you guys for increasing the wages and stuff, and I know that it wasn't just for the Ethics Commission, it was for the whole state when I went, and they did give the state workers a little bump up and stuff. So, but yeah, I think with the work you guys are doing and the growth and complaints and advisory opinions, I think that extra position would be probably very beneficial. And if you do get that position, you need another office,
right?
You need more space, so.
Any other questions or comments? Seeing none, do we have a motion to approve the or ask the Executive Director to proceed with the budget?
Oh, I make a motion to proceed with the bill draft request process consistent with, proceed with the budget building process consistent with commission direction.
I'll second it.
Moved by Vice Chair Wallen, seconded by Commissioner Lowry. Do we have any other comments on the motion? Seeing none, all in favor, please say aye.
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 Any opposed? That passes unanimously among those present. That brings us to item number 10, which is the recognition and presentation of a proclamation honoring Commissioner Teresa Lowry's years of service to the commission. I think Director Armstrong has gone to get the proclamation. You want to read it? Would you like me to read it? I think you can read that. Should be fine. I may need these to cheat with. So it says, whereas Teresa Lowry Esquire was appointed to the Nevada Commission on Ethics by the Legislative Commission and served with great distinction as a valued member from May 2018 to March 2026. And whereas Teresa received her Bachelor of Arts in Psychology from the University of Nevada, Las Vegas, and after working in Child Protective Services for several years, earned her Juris Doctorate from Lewis and Clark Law School in Portland, Oregon. And whereas following her admission to the Nevada State Bar, Teresa returned home to Clark County to join the District Attorney's Office, where her passion for public service resulted in a 24-year career as a prosecutor serving in the Crimes Against Women and Children units, juvenile justice, child welfare, and support divisions, and her service on many boards and task forces, partnering with local government, nonprofits, and community organizations. And whereas Teresa's community service endeavors are exemplified by her work as a certified leadership development facilitator and coach with Aegis Learning, volunteer work as a board member for the nonprofit Public Service Nevada, and as a mentor with Hope for Prisoners. And whereas Teresa's vision and wisdom has moved the commission forward in fulfilling its mission to ensure the public's trust in government through increased outreach and education, including statewide training presentations, issuance of detailed confidential advisory opinions, and the development of procedural regulations to enhance ethical responsibilities of public officers and employees while ensuring fairness and due process of law and commission proceedings. And whereas Teresa's tremendous legal acumen, commitment to the truth, and passion for proper government accountability empowered the commission and was instrumental in appropriately steering litigation, resolving matters through considerate and persuasive mediation, and the issuance of thoughtful, well-reasoned opinions. And whereas Teresa's demonstrated her unwavering commitment and dedication to our mission and upholding ethics in government, with her most memorable attributes being her sharp legal mind, deep understanding of Nevada law, commitment to fairness and transparency, dedication to the public good, and interminable professionalism. And therefore be it resolved that the members and staff of the Nevada Commission on Ethics hereby express their extensive gratitude to Commissioner Teresa Lowry Esquire for their dedicated service to the state of Nevada and the Constitution of the United States.
Thank you. Thank you. Wow. Oh my goodness, thank you. That's lovely. That's overwhelmingly.
But it's true.
Thank you. It's been an honor and pleasure to serve on the commission. And I'm going to be very targeted in my remarks. My thanks and admiration goes to the entire team behind the scenes. You all are the spine and the backbone of the commission. You're the ones that hold everything together. And that is our executive director, our commission counsel, our associate counsel, our investigator, our legal researcher, and executive assistant, and our outreach and education officer. You may be small in terms of volume and numbers, but you are mighty. You all are an exceptional group of professionals. You deftly navigate the idiosyncrasies and personalities of the commissioners. And there aren't any of those, right? There aren't any idiosyncrasies or personalities involved, right? You operate without fear or favor in a time when upholding the rule of law is so important. Thank you for your service to our state. I appreciate your hard work, professionalism, and commitment to our mission. It has been my honor and pleasure to work with all of you. Thank you.
Any other comments for the commissioners?
Well, I just want to say, because I've worked with her for Commissioner Lowry for most of her 8 years, other than like 1 month. And it's been a great pleasure working with her. I've really appreciated her her leadership and her understanding of the ethics law. And as former Commissioner Brian or Dufferin said, just her understanding and her willing to say what needs to be said succinctly and to the point. And I think I remember the first case hearing we had was Antonero, and you made the motion to fine him, and some of the other commissioners didn't want to fine him or say that he had violated it, but she had the backbone to go and do what was right, and I appreciated that. And what I also like is she's always been very thoughtful. The proclamation said a lot of things I was going to say, so like her great legal mind. She always treats everyone fairly. She treats each case the same as, to have the law be treated the same. She doesn't treat one case differently than another with the similar circumstances. And I think that's important, having that consistency. And I'm really going to miss her because she was here when the commission really kind of started to change and became the commission it is today. So I just want to thank you. You'll be missed.
Thank you.
Thank you, Vice Chair Wallen. Other comments?
I wrote a little something I want to say to
Okay.
Commissioner Lowry. I'm very sad to be saying goodbye to Commissioner Lowry today. Commissioner Lowry's service has had such a positive effect on the commission, but also particularly on me. Throughout the time I've shared here with Commissioner Lowry at the commission, she brought not only her sharp intellect to the position, but also a genuine sense of care and humanity to the work, which I think is evident from her legal career. She has a way of speaking clearly and honestly, but with respect, and always with the goal of reaching the right and the fair outcome. It's been an honor to serve the commission during the last 5 years of Commissioner Lowry's term. And while she will be deeply missed, the example she set of integrity, thoughtfulness, and genuine care for others will continue to impact this commission and particularly myself. Commissioner Lowry, I'm really appreciative of your work and guidance, and I hope you have a lot of fun in all your ongoing adventures.
Thank you.
Comments, thoughts? Mr. Reynolds, did you have something you wanted to say?
I did. I just wanted to say it's been a short span of time, but I really appreciate Commissioner Lowry's always her comments and her legal mind in terms of helping us define those issues under the law, which is important for somebody who's a non-attorney on this commission. But I also appreciate the fact of the quality of her experience in today. I oversaw 23 boards and commissions during business and industry, and it's extremely difficult to get qualified people that have a deep, rich background in terms of being able to comment and add substance to the commissions for the tough things that they have to decide. And Commissioner Lowry, you're with your breadth of experience and your knowledge of the law, it makes a large difference for this commission and for any other commission that you may want to get on, because it is very difficult to find that quality of an individual coming on to or being appointed to a commission. So I thank you for your service, but also for your depth and rich understanding of the law. We appreciate that. Thank you.
Thank you.
Yeah, I will, I'll say that as the, the director coming in, I really appreciated your experience in the gladiatorial arena of criminal prosecution and understanding how it works in this role. How often we'll talk to folks on team, like we have an extra burden as the government a lot of times, and I know you understood that, and not just the nature of contested cases, but also agency operations and playing at that higher level. I appreciate our shared experience at different times in the child welfare system, which changes folks, and everyone who touches that system is changed by that system. I really enjoyed our trip to and from Ely for that commission meeting, where we had to talk about all sorts of stuff, but mostly experiences in public service. And I think in addition, just your general belief and real accountability. I know walking into a stipulation or an agreement, if someone's going to want something more, it's going to be Commissioner Lowry, which we saw today, and that's it's helpful to have that type of strong voice on the team that says no, like people should be held accountable. So I appreciate that, and when you always called, it was something important. I think it was, we found a way to say it, but you don't speak all the time, but when you do, everybody stops and listens, and that's a remarkable quality. So I thank you for your service and your guidance and your leadership.
Thank you. Thank you.
And I want to echo that certainly every commission needs, the whole point of having a commission is to have differing voices sometimes, and you and I don't always agree on things, but I always appreciate the comments that you make, because they make me think, and they make me think about why I believe what I believe, and sometimes I'm persuaded, sometimes I'm not, but nevertheless, I always have to think about it. I appreciate that every commission needs that, and needs that exchange of ideas and people who are willing to speak up and not just say me too. And I appreciate you doing that.
Thank you. Thank you.
Well, I'd like to also add that although I don't know you at all, basically, when you make your comments and analysis, or your comments have actually been based on your analysis, I've had to relook at some of the cases and the situations to find and come to my own conclusion based a lot on what you have offered, and I find it very good analysis on your part, and I've always appreciated that, even though it's only been, like Commissioner Reynolds said, a couple of years, but I've always appreciated your input. So thank you.
Thank you. I very much appreciate all of your lovely, lovely comments. I thank you so much.
That brings us to item number 11, report by Executive Director on agency status and operations. Executive Director Armstrong.
Thank you, Chair. Just a few items today. There's some shifts in our assignments for the Administrative Services Division, so we're working with that. Actually, so the person who built our budget last time went away for a bit, and she's back to help us build our budget this time. So it's nice to have someone who has experience with our quirky and small budget. We are starting the annual report process. We had, and the other reason I put this, we had a refrigerator that we had to replace. We may need a budgetary work program to cover the cost of that, but it was a journey. It was our, I think, 1978 refrigerator finally went out in the office, and Buildings and Grounds supplied, I think, which was an old prison industrial kitchen for us for a couple months while we tried to figure stuff out, and executive assistant Saldana finally were able to make it all work. But one day there were days where we had multiple refrigerators everywhere, and so for us and operationally, that is good. I want to thank the legislative committee. It is always an adventure, and there was a lot of work that the commissioners did and provided input and helped guide that conversation. What I didn't say today, and what I indicated, that the governor's office had initial meetings. We have a handful of items. It's probably going to be about 50 pages less than the last time we attempted legislative changes, because you're focused on what really needs to change. And so that's exciting. Staff is holding a strategic meeting tomorrow. We try to have an offsite every once in a while to really just take a breath and see where we're going, and we'll be having that. And having our strategic plan really helped clarify where we wanted to go with our budget and everything else. So thank you for that previous work. As I said, we had the budget update. We've received payments in 2 cases where we were pending payments. Some took a little bit of wrangling to get, but I think we will see a pretty sharp increase in the payments of fines received for this year. Review panels have been hard at work. You'll see there, one that we referred that we had stipulated agreement of today. The 2 that are marked as deferrals, those individuals have agreed to those deferrals. I think we're just pending review panel approval of those. But in both of those cases, those will not be coming before the full commission. And then upcoming meetings, in May, we have a potential adjudicatory hearing and administrative matters, and then June will be our rural meeting in Elko. So we'll start talking about logistics for that here shortly. And I'm happy to answer any questions that folks have about the general operations.
Questions for Executive Director Armstrong?
I don't have any.
Might have to go visit this place before hopefully you get to move.
Yeah.
To see.
But you won't get to see the
refrigerator.
3 refrigerator situation.
And it's, I will say the other thing that sometimes we get asked is like, how many people come and visit you? We're on a 2-floor building, and below has been doctors for a long time. And they departed a couple months ago, and since they departed, we had nobody, because people would just come to our office looking for a doctor because the signage wasn't clear down below. And so mostly our job, and people, not a lot of walk-ins, like, hey, I just witnessed this ethics violation. I mean, folks are more comfortable by email and phone calls now. And so we're doing much less medical redirection in the office.
We're in business, so I think obviously you can find it.
Yeah.
Any other questions or comments? All right, then we'll move on to item 12, report on outreach and education. Outreach and Education Officer Harvey, if you would provide your presentation.
Yes, same Harvey for the record. I'll go through it really quickly today. I know we've got lots to cover still, but my report outlines our recent trainings, those trainings that we have coming up. We're at a little bit over 1,000 people trained so far during this fiscal year. Some analysis on how we're comparing to prior years and some of the mitigating factors contributing to that. It was, I believe, in our January report, and I think I like that concept. We're going to continue that on an annual basis as well. With regards to training partnerships, we've expanded, we're mostly conceptually how we're thinking about this, but we've had commitments with regards to, we call them memorandums of understanding, but basically agencies who are willing and committed to train their entire agency from the agencies listed there, as well as hopefully some of those coming soon. In addition, we've tried to conceptualize what improving ethics at an agency-wide or top-down level looks like, in addition to, our unit of measurement really at the commission is we have jurisdiction over individuals, right? But how do we improve ethics from an educational standpoint, prevention standpoint, top-down, creating, culture or messages from leadership. And so that's where some of these steps outlined in the graphic in the report are coming from. And so we began some of that process with a couple of agencies and continuing to explore partnerships at other agencies as well towards these efforts. So moving on to in-person outreach, recently at the Emergency Preparedness Conference, Ross trained them with them last year, and so I kind of continued that on this year as well. Not only, a training and a breakout session where you get a portion of their attendees, but also just kind of harassing them at lunch with resource cards and trying to get my face in front of everybody there so they don't forget that we exist, which has been very helpful, I think. Digital outreach, we're looking to expand our social media following and subscription to the newsletter. I've been trying to frame it as, we know that you don't have an ethics question every day, but if you get something in your email inbox or on your social media feed that reminds you we exist and we have resources and cases, right? That's always a good thing. So going to keep ethics at the front of our mind. And then some data points showing the breakdown of our collective following, which is interesting to see as well across LinkedIn, X, and our newsletter as well. It's a cool picture of that report as well. Well, Ross spoke to it a little bit earlier in terms of our budget requests, but the last page of my report outlines our public records requests as well as, general information requests. Where those are coming from, I believe probably with today, we're close to 300 this fiscal year. Next report, I'll let you know again, like last time, what percentage increase that is from the prior year, but yes, we're keeping us busy.
Thank you. Questions for Sam?
Comments?
Comments, please.
Well done. Just really well done. The training, the number of different agencies, the volume, your report. I love this, your agency's Road to Ethics Gold. It is just really nice work. Good job.
I'll second Commissioner. The training was exceptional. The numbers look so good.
Commissioner Smith, any other questions, comments?
I do want to just say, I do also think our kind of dramatic rise in advisory opinions can also be linked in part, at least back to outreach and education, because people are aware. They get links, they get this information. I just know that's got a lot to do with, as we increase our education, we get more advisory opinion requests. It's a good thing. And I think it's linked together.
Thank you.
Yeah, no, I think you're doing a great job. And you actually trained one of our Commissioner Dufferin's daughter not too long ago. So he must have come back to dad and gone, hey, that ethics thing you hammered on about. Yeah, exactly. But no, I think it's good, and your social media outreach, I love it. You've got some pretty cute little things in there. Gets your attention.
Vice Chair Wallen is an exemplary example for fellow commissioners and staff as well, reposting almost all of our posts, broadening our engagement, bringing our educational information to as many eyes in public service as possible.
I'm a little slow right now because I've got other things. Homework.
Sometimes it's helpful for it to come a week later and kind of whatever algorithm math is happening, right? We never know. Thank you all very much. It's tricky. Sometimes you talk to someone at a training, you really try to encourage them to submit that advisory request, and you never see it come through, but it's great to see that trend upwards as much as it makes the pile on Melissa's desk ever higher.
I'll take it.
Thank you. All. Vice Chair Wallen, I don't think the tax season is a good excuse for being sad.
So how's he doing?
Nobody else does
See? See?
I think that brings us to the end of my.
Yeah. Yeah.
I think the plan is to take a lunch break at this point.
And we'll just reconvene at 1.
And come back at
Reconvene
1
about
o'clock.
1 o'clock.
Right
1
at
o'clock.
13. Now, I served on the review panel. Who are the other members of the review?
As did Commissioner Miller and Commissioner Lowry.
Okay,
Yes.
and so I will not be back for that matter. And I will turn the rest of the meeting over to Vice Chair Wallen.
All right, thank you.
With that, we will take a break until 1 p.m.
Thank you.
Thank you.
Place for the hearing on deposit of motions in the matter of ethics complaint number 25-024C regarding the conduct of Lieutenant Governor Stavros Anthony. Would the parties' attorneys please identify themselves for the record?
You want us first? Thank you. On behalf of the subject, Lieutenant Governor Stavros Anthony, myself, Gus Flangus, and Kimberly Stein.
And Ross Armstrong, Executive Director on behalf of myself today.
So before we get into the hearing process, I want to quickly review the process for this hearing that was set in the notice of hearing and order regarding arguments on motions issued to the parties on March 3rd, 2025. March 3rd, 2025?
I guess it'll be 2026.
2026.
I'm still back in 2025, I guess.
This hearing will be generally conducted in the following order. Executive Director Armstrong and Mr. Flanagan will each have 10 minutes to present their arguments in support of their motions, starting with the Executive Director. Both sides will then have an additional 5 minutes to provide rebuttal arguments. Members of the commission will then have the opportunity to ask questions. The commission will deliberate on whether either of the parties have met the standard for summary judgment. The commission will conduct its deliberations in private, but proceedings will be open to render a decision. If the commission determines that summary judgment is appropriate and finds any violation of NRS 281A, the parties will then each have an additional 5 minutes to provide an argument on the issue of willfulness of any violations, followed by questions from the commission. The commission will then deliberate regarding the willfulness of any violations in private, but open the proceedings to render its decision. If the commission determines that there is a willful violation of NRS Chapter 281A, it may impose civil penalties authorized by NRS 281A.480, and it will impose any statutory remedies required under NRS 281A.480. The commission counsel will time the parties' arguments and indicate when the time has expired. Before we start, I want to make clear the scope of today's hearing. All arguments, statements, and responses to commissioner questions must remain focused on the alleged violations of the ethics law and the facts and legal authorities that are relevant to those alleged violations. This hearing is not the time or forum for arguments, commentary, or statements regarding unrelated matters or broader political positions. If a party begins to address issues that fall outside the scope of the alleged violations and the applicable law, commission counsel or I will interrupt and redirect the speaker. The purpose of this hearing is to address the specific allegations before us in a fair, orderly, and legally relevant manner, and I expect all parties to conduct themselves accordingly. So, Mr. Armstrong, please proceed.
Let me get my presentation now. Thank you. In the matter today, it's not a question about what happened, but a question about whether what we all agree happened violates the ethics law. There are no disputed material facts remaining in this case, and I believe that I'll show by a preponderance of the evidence you should rule in favor of granting my motion in this matter. Okay. The allegations today that I'll ask you to find is that there are violations of 400, 7, and 9 regarding to the amplification of Mr. Anthony's private social media accounts and in support of the task force. The first major section of this complaint involves the amplification and the use of social media. This is really modern facts for a long-standing ethics rule. In Hammergren, this commission determined that a lieutenant governor who used letterhead to support a bill that was going through the legislature was a violation of the office because he had a pecuniary interest in that bill and he was using the resources of government to promote it. Social media operated by government agencies is just like the letterhead of the past. It is communication saying, this is the government, listen up. We are endorsing what this message is. And so in this case, the Office of the Lieutenant Governor social media accounts operate like the letterhead. And the mailing list of the past is now a list of followers in social media, and just hidden posts is now required no stamp. It's important to establish that Mr. Anthony has a private social media account. He uses it for a number of purposes, including his personal political interests and information. He posts endorsements from different candidates, and he otherwise uses it to speak to constituents. The purpose of this social media is to build a campaign, a following for himself. And this commission in his prior cases, as I explained in the motion, he has a pecuniary and significant personal interest in maximizing the reach of his private account. Let's talk about the mechanics of reposting and how that works, because it's important to understand. So Mr. Anthony has a private social media account and there are followers to that account. The government account also has followers. When the government account takes the private account and reposts it, it delivers that private message to anyone who follows that government social media. If you think about it, not in the realm of social media, but if you were to think about it like if Mr. Anthony owned a deli and in the lobby of the Lieutenant Governor's office, there were advertisements for the deli, it's that sort of advantage, right? Anyone who comes to want to interact with the Office of the Lieutenant Governor then gets this private message from Mr. Anthony, right? You can pay X, or let's use Twitter, to put your stuff into people's feeds. In this case, Mr. Anthony can just use the government account. It is undisputed through admissions, through depositions and other testimony that staff helped to curate the content on Mr. Anthony's private social media account, taking photographs, developing draft language, and then having Mr. Anthony post it to his private account. If you think about it, back to the deli example, it's like having his state staff at the deli making sandwiches. In addition to having staff create his own private content, Mr. Anthony's government account reposted and amplified that private account. And you can see that through documents in the record on numerous occasions. This creates an unwarranted benefit. Who wouldn't want a government account to repost and amplify and endorse your private comments? But he has special access to that government account as the Lieutenant Governor. So when it comes to the social media part of this case, the facts, the undisputed facts show that there was use of government staff, equipment, and resources to either amplify or create this private social media account that the Lieutenant Governor had. He has a significant pecuniary and personal interest in that account. That use of the government equipment to promote his private interests violates NRS 281A 407 and 9. 9 in particular is the use of staff, and 407 is the use of equipment and time. Additionally, when it comes to the use of social media, there's a violation of 402. I talked about that unwarranted advantage. Wouldn't anybody want a government account to amplify their personal private account? He has special access as a Lieutenant Governor. That's him securing an unwarranted benefit. For the unwarranted benefit violation, there doesn't need to be any private interest involved. We'll now talk about the second part of this case, which is the task force. In the fall of 2024, he had staff look at creating a task force. It launched in February of 2025, and the undisputed facts show that he used government resources to support that task force.
My office pitches in on everything.
So, Lieutenant Governor, to be clear, you are using staff time because that would be a resource and that is at a cost to the state where we could be allocating those resources to the actual responsibilities of the office. Is that correct?
Yes, I have employees that are helping me with the task force and actually with everything that I do in the Lieutenant Governor's office. And that's I decided that one of my responsibilities as Lieutenant Governor was to support these female athletes.
Additionally, the materials in the record include admissions that staff spent time working on the task force. That's similar to the Augustine case where staff were maintaining databases to support her campaign. In his response, Mr. Anthony said the actual resources used for the task force were some phone calls, 3 or 4 flyers, limited emails. That's similar in scope to the Matson 2011 case where she had staff create some flyers and drive them to anti-recall campaign. Also in the record, we have emails showing that state staff are using state email to coordinate the efforts of the task force. And so subordinates of Anthony were being used to support the task force in coordinating emails, writing press releases, and then as also indicated in the interrogatories, the task force rally agenda and other materials to support the task force. As the Lieutenant Governor said, his office and resources were fully engaged.
And I'll tell you right here on the show, my office is fully engaged, fully supporting. Our resources are focused on many things in my office, but one of them, and it was my decision, was to focus on protecting our female athletes.
Now, under the ethics law, there are essentially 4 types of interests that you cannot use your government position to benefit from. When we talk about the task force, the only one alleged is a significant personal interest of the Lieutenant Governor. The opposing motion talks a lot about these other, there's no commitment, private capacity, no pecuniary interest. We don't allege those, and a significant personal interest alone is sufficient, as this commission has determined in many cases. In Bowles, Matson, and Sonora, Don, it was just college courses he was taking. And then in the campaigns of others, you have no commitment or private capacity to another campaign. You don't have pecuniary interest, a significant personal interest. Enough is alone. And so we know that government resources we use. The question in this case is really, is this interest, the task force, an interest of the office of Lieutenant Governor, or is it just the person holding the office? That is the question on the second prong for you today. No matter what you think of the content of the task force, the question is this something that the office is involved in? Now, they walked in here, they have what could be called a sham declaration where he says there is no personal interest. That's a decision for you to make, whether he has a significant personal interest or not. It's not his opinion. And we can listen to him for guidance on if he's interested in the task force or not.
So I decided that I was very passionate about protecting female athletes. I wanted to make sure, especially when it came to the UNR volleyball team, who came out very courageously in their stand. I wanted to support them, and that's why I created this task force. My business, my focus as Lieutenant Governor is to rally people together to make sure that not one female.
So the next step, right? So we know his words. He says he has an interest in this task force. It would say, okay, if this is the interest of the office, is there evidence that the office is working on this in a government way? And as we went through this case, it's determined that no, right? And Anthony, in his response, he says it's not situated in the Lieutenant Governor's office. His chief of staff said it is not a function of the office. We try to say, hey, are there documents, reports, are there meetings where you've talked about the task force and gone to the different boards and commissions you sit on? Did you take this information that the task force gave you and do government work on it? And in every instance, in that case, the answer was no. So there's no evidence that the office is treating it as an interest of the office. It's a personal interest of the Lieutenant Governor. And so when it comes to the, that's your time, baby. All right.
That's it?
That's it.
Are we stuck to specific timeframes?
Yeah,
Oh.
that's what it said in the very beginning.
Oh, yeah.
They each have 10 minutes. Okay,
Perfect.
all right.
All right, thank you. I'm going to go pretty quick because there's a lot of information to cover here. First of all, what I want to point out is something very technical in this matter. The ethics complaint in this matter was filed on February 27, 2025. The order on jurisdiction issued on April 14th, 2025. Then the notice of complaint, investigation, and notice of additional issues, in fact, issued the next day on April 15th, 2025. So let me read you what the notice said here real quick. Specifically, the additional issues and facts discovered during the jurisdictional review process include use of government social media accounts belonging to the Office of the Lieutenant Governor, the Office of Small Business Advocacy, and the Nevada Division of Tourism to amplify and promote private non-governmental political and personal accounts of Stavros Anthony, Sarah Johnson, and others.
Then says the primary focus of the complaint allegations related to the task force is the determination about whether the task force is a personal interest or an interest of the office of the lieutenant governor. That's the only thing it says. So we've got allegations about amplification of his personal account, but this is not what we're on notice for. We're here solely for the task force. So the issue in front of you, from our perspective, is whether or not that was a significant personal interest of Mr. Anthony. So the way they're getting to where that's a significant personal interest of Lieutenant Governor Anthony is they played that for you a little bit, and in their answers to the interrogatories is basically what they just played for you. They said, yeah, in their motion they say to try to establish a significant personal interest, says you can rely on the lieutenant governor's own words that the task force is a personal interest. I decided I was very passionate about protecting female athletes. I wanted to support the University of Nevada Reno volleyball team, who came out very courageously on their stand. That is why I created this task force. Now, this was his testimony in front of the Joint Meeting Senate of Finance and Assembly Committee on Ways and Means. So from that verbiage right there, they want you to extrapolate that that is a significant personal interest on the part of Lieutenant Governor Anthony. And that is a huge stretch. And let me tell you why. So let's put this in another thing. Let's say I'm a state public officer and I'm out there, you know, I've been in office for about 1.5 years, and I say I'm very passionate about healthcare. I'm very passionate about veterans' rights, which I am because I am a veteran. And then all of a sudden, I post on my media, my official media, that, hey, I want people to get behind the veterans or something like that. Am I now in violation of the ethics laws because I said I was passionate about something? They want you to have no passion. It's the way they're putting this on anything, because if you have passion, you got a significant personal interest. That's not what the law says, and that's just a huge stretch in logic to pull that from there and then say that that's a significant personal interest. I don't think anybody here disputes that this issue is of great magnitude across the United States. It's on the news all the time. It's on social media. It's on posts, podcasts, etc. And to just say because I'm passionate about this issue, it transforms it from a important public issue to a significant private issue takes too much of a leap. Now, what they're not telling you when they made their presentation in their pleadings, there are certain things in those statutes that they have to show. Now, for example, in NRS 281-400 subsection 7, they got to show that he has a pecuniary interest, which he doesn't. They've admitted. They have to show that he had a commitment in a private capacity, which they haven't shown. So what they have to fall back on is he had a significant personal interest in this matter. And I need to remind everybody here, there's no law, there's no rule, no regulation, no policy that prohibits the lieutenant governor from advocating a specific position. There's no law, rule, or regulation policy that says he can't do it on his official sites, because every single state officer puts stuff on their website. I'm pushing for this legislation, says the governor. I'm doing this type of lawsuit, says the attorney general. Those are things there that are on those lawsuits. So what they want you to do now is to take this, what he said there, that he's passionate about it, and turn that into a significant private issue. In addition to that, the statutes under 402, NRS 281A 400 subsection 2, it says a public officer or employee shall not use the public officer's or employee's position in government to secure or grant unwarranted privileges, preferences, exemptions, or advantages for the public officer. And in that section, it says unwarranted means without justification or adequate reason. He had plenty of reason for this because it's an important issue in the state. It's an important issue across the United States. Whether you believe it's an important issue personally, it's out there. And so there was no unwarranted thing. And then as far as subsection 9 goes, you have to show significant personal or pecuniary interest or a commitment in a private capacity through the influence of a subordinate type of thing. They haven't done this. They just talk to y'all in conclusory terms saying, you know, we're not disputing that he formed the task force. We're not disputing that he used letterhead. We're not disputing that he used staff to help it. What we are disputing is that contrary to the position of the director, he had every right to do this as the lieutenant governor. It's an expression of free speech. And y'all aren't really, I don't mean to say this to y'all, but y'all aren't here to really determine, you're not the gatekeepers on what somebody can and cannot do in that office. Your job, I believe, is to determine whether there was a violation of ethics. A lot of these cases these guys are citing, they don't apply here. For example, the Antonoro case. The guy was over there, he's the sheriff of Story County, and he's got a child custody dispute. So he takes his office over there for the sheriff, and he uses it to do supervised visitations. Matson's case, this was a crazy case. The lady's getting recalled, and she's in the middle of a heated recall campaign. The person working for her is one of the folks that's doing the recall, so she starts trying to fire her, starts using her office to trash her, and everything else. These cases don't apply here. This is a legitimate public interest that Lieutenant Governor Anthony was advocating for, and it somehow gets transmogrified, using a fancy legal term, into a significant personal interest, and it's just not there. The facts don't support that. As far as his retweeting, or I don't know if you call it retweeting, I'm not a big social media guy myself, but reposting, if you're going to go down that route, once again, he wasn't a candidate at that time. Okay, the statutes define when a candidate is. You're a candidate when you file for office or you're on the ballot, neither of which. They take some nebulous cherry-picked testimony from his deposition where he said that I am going to run for re-election. Then they asked him, when did you decide that? Well, he goes, I couldn't remember. Well, they didn't ask him, did that happen before this occurred? Did it happen after it occurred? And then in talking to my client, he was able to put it together when he actually decided to run. And that was August of 2025, well after when all these took place. All those cases that they're using involve, like the Seagram case. She's in the middle of a campaign. She's a candidate for mayor running at that time. All the folks in all the cases that they cited, these are your opinions, all say, they were in the middle of an election. And Mr. Anthony was not in the middle of an election at that time. He had just gotten through. This is during the legislative session. This is about 1 year into his time. And so, or 2 years, maybe somewhere around there, close. But the bottom line is, all they can do is just throw stuff on the wall and say, he used social media for this. He reposted from this. He formed this task force. Therefore, he's guilty without applying those facts to the law whatsoever. Do I have any time or am I done?
You got a minute left.
All right, thank you. So I just want to make
Well
sure.
with your time.
I want to just make sure I get some of this in here. As you look at this, the way it's all coming down, you can't just find somebody guilty of this thing without them being appropriately put on notice that that's what they were doing. And again, because I blew through this real fast, now your order on jurisdiction said, put it out there for what the additional facts are and the additional charges, and they did. The notice of complaint that I just read to you is all about this task force. And we addressed that task force predominantly in our pleadings. And I even saw in the reply brief, oh, they didn't address all these other things. Well, they didn't do it. Now I will tell you that there was some other evidentiary materials provided to us, but I mean, are we supposed to guess what the purpose of those additional evidentiary materials are for? Because, from our perspective, it's all about the task force and nothing else. Thank you for your time, and hopefully I got through it as much as I could.
You did good. Right, Executive Director Armstrong, you have 5 minutes.
Thank you. I think if you look at the notice document, it's very clear what the commission was looking into. In addition, that notice happens before the entire investigatory process and before a review panel determines what are the items actually going to be before you today. I want to address the constitutional question about the First Amendment. There is nothing in the ethics law that restricts a government official's ability to speak out, to yell from the rooftops about a matter that they believe is important. But as Justice Scalia said in Kerrigan, once you start to employ the mechanics of government, those First Amendment concerns fall to the wayside. Right? The issues here are about the use of staff and the mechanics of the office, that modern day letterhead, sending it out into the world. And so we would never say that the Lieutenant Governor can't go out there and speak on matters that are important to him, but you cannot use your government resources to do so. The commission agreed also in Hammergren, where he was trying to promote a bill that was going to be passed. It benefited him in his private practice. And they looked at that and said, look, this letterhead, this is problematic. This is a violation of our ethics law. You showing up to testify about an issue that you're passionate about, not a violation of the ethics law, right? That's similar matter here. The Lieutenant Governor was free to establish this task force in its private capacity, but it is not an interest of the office. It's his own significant personal interest. We know that because if you look at, was the office acting like it's one of their interests? No, they don't have meetings about it. They don't take that information anywhere. Other than getting it set up, having a couple rallies and launching it, the office was not involved. In some of the motions, there's talk about the Lieutenant Governor's inherent authority, and I just want to make it clear that inherent authority is not unlimited authority, right? The whole concept of inherent authority is you're given these tasks, and now in our system of government, that's in our Constitution and the statutes. The Lieutenant Governor doesn't get to decide which tasks are his offices. They're set by statute, and you can do the necessary things to accomplish that, right? We as the commission have the inherent authority to host webinars and have a social media for educational outreach because we've been tasked by the law to go out there and educate folks about the ethics law. Inherent authority has to be tied to the actual specific authority that you have. It would be like if I thought that stamp collecting was super important and I went out there and said, we're going to have an ethics director's task force on stamp collecting, right? That could be fine. But the second I use Curtis or Sam to go support that task force has nothing to do with what the taxpayers have said this office should be funded for and should do. I also want to discuss a little bit in the motions, they talk about the purpose of the task force is to research and advise the Lieutenant Governor. 419 days passed between the launch of the task force and the first time you see the phrase research and advise, right? If you listen to the Lieutenant Governor's clips, you listen to the purpose is to promote this policy. It's a campaign for a particular policy change. It is not an interest of the office, but the concept of research and advise, it's not there, right? 419 days until they came up with that phrase. No evidence that there's any research or advice done. The request for production show that there's no actual research or advice going on. I'll close again by saying that this is not a question about what happened. We know what happened, so a ruling on summary judgment today is appropriate. The uncontested facts show that by a preponderance of evidence that government time, equipment, and staff were used to amplify Anthony's private personal social media platforms. By doing so, they created a warrant benefit. The uncontested facts also show that by preponderance of evidence, government time, equipment, and staff were used to benefit the task force, which, when you take the evidence before you in the record and apply it to the law, is clearly a significant personal interest of Mr. Anthony and not an interest of the office. Some of these facts are modern, but they're long-standing rules. Mattson, Augustine, Antonoro, not great departures from this Anthony case. So I would ask that you grant the motion for summary judgment in the executive director's favor at this time.
Thank you.
Thank you. I'll start off by addressing the Hammergren case. I'm pretty familiar with that action because I was the lead counsel for Physicians Task Force way back when they were trying to do that special session. And I was present when Dr. Hammergren made those statements. The difference between what he was doing at the time and what Mr. Anthony's doing is Hammergren had a medical practice. The whole issue was whether or not what the medical malpractice insurance rates were going to be, tort reform for medical malpractice. If that passed, which it did, it would benefit him in a pecuniary way because his malpractice insurance rates would be going down. That's the difference here. There's no pecuniary interest that Mr. Anthony is receiving in this case whatsoever. Not a dime. No personal commitment to anybody. Not a dime. So it's completely different. Again, Antonoro doesn't apply here because, again, that was a personal pecuniary interest because he was able to use the sheriff's office instead of using some other facility to do his supervised visitations. None of these cases that they cite apply in this type of situation. None. They're all involving somebody who's in the middle of a campaign, or it's because of a pecuniary interest that they received or some other type of interest. Although they'll also call it a significant personal interest on the part of Antonoro, which it was. He's having his kids meet over at the sheriff's office. And I'm familiar with that one too, because I sued Antonoro twice in the past. And so I know all about what his antics were. The bottom line on a lot of these things is, we hear that the task force, what its function was. It's been this way all from day one. It's to advise Lieutenant Governor Anthony about these issues. It's very important. It's complicated. Nobody here can sit here and say this is a simple issue. It was there to advise them. It was there to do some research on it, to meet with coaches. They put a whole hodgepodge of people together on this task force in order to get the information that he needed. The fact that he doesn't turn in a report or anything like that, that's a red herring, nor did they ask for anything like that. The red herring here on that is, if I've got my advisors over here and I'm asking them for advice, do I print up a report and say what my advisors told me? Answer is no. As part of, that's the whole idea, to advise me so I know what I'm doing, what I'm talking about, etc. Because if that interest is out, not that interest, that issue is out there, I want to be versed on it. Veterans' rights, I want to be well versed on veterans' rights, healthcare, taxes, everything that affects us in our day-to-day life. You want to be well versed in order to communicate. And let's look at real quick at what all these social media accounts are for. Everybody testified that this was to interface with the constituents. That's really what it is, to tell everybody what is going on with your lieutenant governor. Hey, you elected him. You want to know what he's doing. And the only way he can get it out in the mass is through social media. And again, at the time that these things were going on, that personal account of his he was not a candidate for office. And so, but I don't even think those are even part of this hearing, because they never really provided us one iota notice that this is what they were going to do. As you look at this, he's also about inherent authority. He's the president of the Senate. That's what he's got. And I know the case law says that he doesn't get the same protections as a legislator on this, but he is still the president of the Senate. He does have a gavel, he does have a voice, and you need to be first on a lot of issues. So he's got inherent authority to look up these things. It's part of his job. And I don't mean to put it this way, but he's a heartbeat from the governor. It's incumbent upon him to know what's going on in the state in case the worst happens. And they want you to throw all that away because he said, I'm passionate about the issue. And for some reason, in the minds of the director in his office, being passionate about it makes it a significant personal interest. If you find a significant personal interest, you're going to be stifling. And I'm not trying to do an open the floodgate argument, but it almost is. Where do you draw the line where it's no longer a violation if I say I'm passionate? I mean, quite frankly, I think it's a privilege to serve public office. And I believe you should be passionate. If you're not passionate, you should go down somewhere else, get a different job. You should be passionate about the issues, important to your constituents, important to you personally, important to everybody. And that's what we have here. We've got a man that was passionate about it. They want to bring it down with the because okay.
What's your time?
Thank you.
Thank you. Thank you. Thank you. All right, at this time, I will open it up to my fellow commissioners to ask questions of either our Executive Director Armstrong. And we don't have a time limit for this, so ask away your questions. So my commissioners on Zoom, do you have questions at this time?
I'm going to defer for a moment. So have your members present go ahead, and I may have some after that.
All right, Commissioner Langton.
Yes, I forgot my microphone was off for a minute. I'd like to ask, I believe it's Mr. Flangus, a couple of questions, if I may. I read your opposition to the motion. On page 11 at line 17 and 18, you state that Mr. Anthony's involvement in the task force is a proper exercise of his direct discretionary power. My question is does he derive his power, his discretionary power, from the office of Lieutenant Governor?
Thank you, Commissioner. That is a good question. There are just inherent powers with any office, just based on the position that you have. Do I have a specific site saying you got this power, this power? I don't know if you can see me or not. I'm making hand gestures. But is there something in there that are saying that you specifically have this power, you specifically have this power, you specifically have this power, and down the line? There are some things listed in the Constitution. There are some things listed on what powers they have. But does there something that says that this is an inherent power? No. Is it something that's inferred that he's able to do? Yes. And quite frankly, it should be taken from the other perspective, whether is there something prohibiting him from doing these type of things? I don't know if that makes it clear as mud for you or.
Well, I understand it. The next question I have is that the chief of staff, I think his name is Pamatuan,
Yes.
I believe testified in his deposition that the task force was not a function of the office of Lieutenant Governor. How do you respond to that?
I will say that that was cherry picked, and I think I can pull out the entire quote in the, and I think I even mentioned that in my opposition. You'll bear with me, Commissioner. I'm sorry, it's probably in my reply brief. I apologize.
That's all right. I didn't get a chance to submit my questions ahead of time, so.
Yeah, it's in my reply brief. It's in a footnote. Sorry about the small type. It's on page 3. And it talks about several of the items that they put in their moving papers.
Page
And-
3 of what document? I'm sorry, please.
I'm sorry, my reply brief to their opposition, it starts on page 2. And it's at the bottom, it's footnote 1.
Thank you.
And I can read it, and it says, to bolster his assertion that Mr. Anthony had a significant personal interest in the task force, the director cherry picks a few items such as the following. 1, Mr. Anthony never requested specific budget authority for the work of the task force. 2, Mr. Anthony's testimony that the task force was basically on its own once I created it. 3, Mr. Anthony's statement that the task force is not situated in his office and its own entity. And 4, Mr. Anthony's chief of staff statement that he doesn't consider the task force a function of the office. Well, here's how this was responded. This is how we responded to this. It says these items are all red herrings. It's a legal term, basically says it doesn't have any weight and it's just thrown out there. And what it goes on to say, and we're not even given as a reason in the director's response to interrogatories. Moreover, they require a huge leap in logic. It is necessary to briefly discuss each of the 4 items listed above to put them in perspective. Pertaining to item 1, Mr. Anthony testified that, no, I am not asking for any money because that's what they were saying, but they didn't put the rest in there for the task force because they do not need any money. They are all volunteers except for me. I mean, I'm involved in it and I have staff people in my office who help me write things up, but that's about it. The task force is primarily all volunteers. So that's one that they cherry picked and only put half of it. And it says, see the motion for summary judgment. Then it goes on pertaining to item number 2, Mr. Anthony's testimony that the task force was basically on its own once he created it was in response to the question as to why he didn't request specific budget authority for the task force. So again, they cherry picked and put a small amount there. Number 3, it says the quote is incomplete. The quote is, under Lieutenant Governor's authority, the task force was created and operated as its own entity to advise the Lieutenant Governor. Then it goes pertaining to item 4, and I'm sorry about the long diatribe, but this is more specific to your question. It says about Mr. Anthony's chief of staff statement that he doesn't consider the task force a function of the office. That was again cherry picked, because here's the full quote. It says, the chief of staff goes on to say, when asked what he considered it to be, he goes, I consider it a group of volunteers that any state agency would rely on for advice, or, learning more of what the issues are. When you're an office of 5 people, sometimes it's helpful to have volunteers offer some advice, since we're a small entity. For instance, we've got a group of volunteers that are veterans, so we lean on them for issues dealing with veterans. So that answers that question, because as far as him saying that it wasn't a function of the office, that was just a small bit to affect, probably a 3 or 4 sentence answer that they didn't bother to put that in there and show you.
Okay, thank you. This is not my first MSJ, so I understand the passion that you said and the words. I have one more question. Is that you said that they're primarily volunteers. It's my understanding, I thought the facts established that Lieutenant Governor's staff was also part of that task force. Is that true or false?
That's false. They were not part of that task force.
So
they just helped in forming it.
Pardon me?
They were not part of the task force. They just helped form it. Sarah Johnson specifically.
Oh, so they did
most
help.
of this on her own free time.
Okay, thank you. They did help form it. That's your testimony.
Did not.
No, I said that they.
Help form it? No, he just said he did.
I said, just so we're clear, does it help if I get a little closer to the mic for you? I said that they did help form the task force, specifically Sarah Johnson, who formed it, who did a lot of the work on the task force on her own time, and even testified into it as such in her deposition.
Okay, thank you very much.
Thank you, sir.
I think that it's former Executive Director Armstrong. This kind of segues into what we were just talking about, but setting aside the work done on the task force, is there a component of our complaint or the commission's complaint where social media content was used, created by staffers?
Yes, this is Executive Director Armstrong. In the deposition of Garrett Tamagny, he talks about creating social media content that was then later used by the Lieutenant Governor's private social media account. And the Lieutenant Governor admitted to that, on the ED Exhibit 224. So as part of the admissions, that the question was, admit that Garrett Tamagny has taken photographs or otherwise developed content later used for Stavros Anthony's account. The response was admit. And then in his deposition, in preparation for his deposition, because we had that admission, we asked him to bring in, hey, bring us 5 examples of social media that you created on behalf of the Lieutenant Governor. And those are found in ED Exhibit 352. He brought in 5 examples. He talked to us about the process. He would be Lieutenant Governor, take photos, send the Lieutenant Governor proposed verbiage for those tweets. The Lieutenant Governor himself was the only one who had access to that account, so he would then take the items that Garrett had developed and push them to his private.
There's a follow-up on that. I didn't see, and you correct me if I'm wrong, I didn't see any evidence where there was testimony or otherwise evidence where he or anybody else testified that these actions of the drafting of a tweet or the photos were done on the job, on the duty.
Oh, yes. In Garrett's deposition, he talks about, in a lot of cases, these would be during visits, right? Official visits. So Garrett would be, especially in the North, Garrett was responsible for the North. Other folks are in the South. So he would be there, and then the Lieutenant Governor would work with them to let's take some photos of this. and then shoot it, and then we post it. So, it wasn't during off time, for Mr. Tamagi creating those particular.
Do you know, what percentage of time or resources were used for the personal content?
Yeah, I don't have a percentage of time or number of hours. I imagine based on the time that it takes, is that that's minimal, you know, for a trip, or maybe an hour at a particular thing, it probably takes, 2 minutes to take the photos. But the commission precedent is clear that any use of government equipment for these personal, private promotions is not.
And I guess the same question to your team. Do you dispute any of the factual characterizations of Director Armstrong?
No, not entirely, but just very moderately. Yes, Garrett did take pictures when they were on trips, because Garrett testified that he is the outreach person for the office in Northern Nevada. And so he's taking the pictures, and what I don't agree with him on there is the content. He said he would give some suggested ideas, maybe what to write. And if you look at the pictures that he submitted, I keep calling him Stavros, but I need to keep his name properly. Lieutenant Governor Anthony was places like the Great Basin Park. And he said, I'm here, I'm very happy to be here and see these fine folks here. And it's got a little caption on there. That's not what you call sitting down writing speeches and content and everything else. And yes, and I will tell you, it did get posted on his private account, and it also got reposted on the other account. But again, I would just like to reiterate this one important detail on this as well. I don't think this is legitimately in front of you right now as far as his private account getting these things, because it wasn't put in anything about that in the complaint. But even if it is, these are legitimate things that they're doing, because the intent was to get it posted. And the reason is to get it posted, again, I'm the lieutenant governor of the state. I was elected to do certain things, and I want to tell you guys what I'm doing. So all of it, in reality, the flow chart's kind of going like this on some of them. I'm not going to say all of them, but what they're complaining of, the flow chart is they're at an important event. It's not even political, just here visiting something, picture taken, caption written on it, posted, and from there posted on the official account. And maybe the flow chart needs to be different. Maybe it should go the other way around. I don't know. Maybe y'all can give us an advisory on that, on the flow chart. We're always, Lieutenant Governor Anthony is very acceptable of whatever recommendations you guys think he needs to do, and he'll implement those. But that's the flow chart. And is it a violation? I can't say for sure, because I can't even tell you from what I've read in these cases and things like that. Like the Seagram case, it's a whole different ball of wax. Again, she was a candidate for mayor at the time. They got a big TV program that they do on Channel 2 for, I'm not gonna say, but I used to be chairman of public, the planning commission, so I was on Channel 2 too. But they got this Channel 2 where they put these shows on, and they rotate it between the city councilmen. And she asked for an advisory opinion. Hey, I'm running for mayor. Now that I'm a confirmed candidate, I've filed, etc. Am I able to get on those TV programs? And that's a whole different ball of wax, because she's a declared candidate at that time by statute. And I think the statute I kind of had a typo on that one on my brief, but it's actually NRS 281A050, which defines a candidate. And it says a candidate means any person who files a declaration of candidacy or whose name appears on an official ballot at any election. None of that was in place at that time. So in the eyes of the ethics law, he's not even a candidate at that time. And so those are the big distinguishing factors from these cases as to the situation with Lieutenant Governor Anthony. Any other questions or?
Was there any?
Chair Wallen, Chair Wallen.
Yes.
I do have some questions. Mr. Flangus, thank you for your testimony earlier.
Okay, I'll do it after him. I know Zoom is tough to follow. Go ahead.
Go ahead, Commissioner Reynolds.
Okay, thank you. Mr. Flangus, thank you for your testimony, earlier testimony. I have two questions. One is that did your client, Lieutenant Governor Anthony, discuss with the governor prior to establishing the task force and getting involved in this about the governor's support in establishing a task force?
I couldn't tell you for a fact on that at all because it's nothing that we addressed or was ever asked about. I will tell you that the governor's come out recently, not so recently, a lot about that issue in favor of what the issue that Lieutenant Governor Anthony's passionate about.
Yeah,
So it's
I'm
not-
aware of that. That's post this issue, but
I could not tell you, going back then whether they discussed it. I
Okay.
apologize. I wish I had that information at my fingertips.
So the second issue and the second question I have is that, and I will tell you, I'm old enough to remember the dialogue that happened between Senator Raggio and Lieutenant Governor Sue Wagner about the duties of the Lieutenant Governor's office, and then the subsequent legislative changes that occurred, establishing a little finer detail as to the duties of the Lieutenant Governor office in there. So what you're saying is that that the Lieutenant Governor has a statutory duty to involve the office in the NCAA's decision on athletics and also the NIAA, their decision on interscholastic activities. Is that what you're saying, that he has the right to insert as part of the duties of Lieutenant Governor's office?
No, sir, I'm not asserting that at all, and I have never asserted that. What I have asserted is he's got the right to advocate for a certain position, not a statutory duty to do those things. I've never even argued that. In fact, I think Commissioner, the previous commissioner online asked me about that. You know, is there something that allows that? And I said, well, you've got these different constitutional duties of the Lieutenant Governor that he's able to perform, and it's all about his right and his his ability to be able to do that from the Lieutenant Governor's office to advocate for a certain issue that's important to the people in the state of Nevada. And
well, I
whether
think there's a difference between statutory advocacy and going in and addressing specific legal issues within the context of his office and having a staff involved in that, as opposed to him speaking to that as an elected officials. So I think there's a difference, and it's not an inherent duty of the office. And I think those duties are well defined in statute and the Constitution. So you're looking at a broader brush and saying that he has that inherent duty to do that, to be involved in those type of activities. Am I incorrect in that assumption?
You're almost correct on it. Yes, I believe he's got not the inherent duty. I think he has the inherent right. There's a big difference between duty and right. And the Constitution does lay out his powers, but let's put in another kind of issue here. All right. So let's say again, I've mentioned this earlier. He's passionate about veterans' rights. There's nothing in the Constitution that says that's a duty or inherent power of the Lieutenant Governor to advocate for veterans' rights or health care or anything like that. There, you know, it's the thing. I think the way this has to be looked at, what is he prohibited from doing? Not what it is that he's allowed to do, because I think he's got wide discretion in that office to advocate for positions, whether it's politically, feasible or whether or not it's politically popular or unpopular or whatever the case may be. As we talked about at the beginning of this, we weren't going to get into the politics on all this. And the bottom line on this is really, does he have the right to do this? And the answer, in my opinion, and based on the way I read the law, is yes, he's got the right to do it, unless the legislature comes up and says, these are the exact duties of the Lieutenant Governor, and these are what the Lieutenant Governor cannot do. And that's where it goes. And I think he can use staff time. I think he can use emails to form and support this venture. And that's what he did. I'm not disputing that whatsoever. He used those things to form and support. And then he says, all right, you guys are off on your own, go do your own thing. Give me your data when when you got something going. And that task force went off on its own. They did their discussions. It's a pretty broad base of folks on there, and they're advising it. That's the bottom line on it.
We'll have to disagree on that, but go ahead.
Well, that's
you can-
what we're here for, but
I guess I will ask Executive Director Armstrong this question, because it seems that we're kind of blurring the lines between being an individual, a private citizen, and a public official, okay? And I know that we've been very clear, and you can tell me more about an individual has the First Amendment right to talk about whatever they want, support whatever they want. But a public official cannot do that in their capacity as a public official. So can you kind of elaborate on that, about public officials kind of not advocating, making sure they don't advocate things in their their public capacity, but in their personal capacity?
I can, and I think what I called in the case of the Carrion 2 cases, Nevada Supreme Court has said, when you're looking at a statute, you got to look at its full context and its purpose. And when they establish the ethics law, it says, we know that people have their private interests, but they are also serving in public office. And the whole purpose of the ethics law is to make sure that those two things are separate. And so, again, at no point in our ethics law do we say, we're going to take away your private voice to be passionate or advocate for something. But when you employ the resources of government, staff, equipment, emails, letterhead, you are then using the people's stuff. It's not your stuff to use, it's the stuff of the people. And you need to use it for what it is used for, right? The Lieutenant Governor's duties are established in Article 5, Section 17 of the NRS. It's pretty clear what the Lieutenant Governor's duties are. But to the extent the other side talks about, like, there needs to be a law that prohibits it. No, there's no rule in the ethics law that says you have to go violate some other law before the ethics law can apply. The ethics law applies on its own. And so the ethics law exists to keep that strong line between your private life, your private interests, and your personal service as a public servant. And the commission is regularly held that you cannot be using your government equipment to benefit those private interests, whether they are, like, I think Prudent is a great example. Out in Nye County, the county treasurer, there was, in that case, he was using just his time in the office and the facility to take courses, I think at LSU, to get more credentials. That was his, personal interest. And so that's, I think, a great example. The political ones where we talk about not your own campaign, right? But when you're endorsing somebody else, you can't be using equipment of the government to go endorse somebody else. You don't have a pecuniary interest, you don't have a commitment, but you have a personal interest in seeing that person. Mattson, in terms of the definition of candidate, Mattson was at the same status essentially that Anthony is today. There was no official declaration, no official recall in place. The commission said, you have a personal interest in maintaining this job, and so it was violated when you had staff take a couple of flyers and go over there. So I hope that answered your question. The whole purpose of the ethics law is to keep personal, private interests and are separate from your government interests. When we go out and train, I tell people, you don't lose your humanity just because you're in public service. You don't have to just sit at home and have no relationships and have no interests. That's not what the ethics law requires. It does require that you not engage the equipment of your office to benefit your own personal interests.
Yes, I haven't, it's not quite related to this, but my question is, because you kept bringing it up that he wasn't a candidate, so that's why there's not a problem. So do you have to be a candidate to have a violation here?
So under the ethics law, there's a specific violation, 281A 520, that says you can't cause a government to spend money for your campaign for election or a ballot initiative, right? That is the only provision in our law that creates the prohibitions based on your status as an official candidate with the Secretary of State's office. So that 520 you don't see a lot because it has to happen during an active campaign cycle. What the commission has said is if you're a candidate for office, you clearly have a personal and pecuniary interest in that campaign or somebody else's campaign for office.
I guess, because I want to go back to you because you're talking about that he's got this broad sweeping thing as his duties as lieutenant governor. So can you tell me what his duties are that are spelled out in the state constitution and in the statute?
Yeah, pretty much. Yes, he sits on the several boards, tourism, a few other things. He's second in line in succession to the governor. He also sits as the president of the Senate. He's, like I said, the various boards, tourism, I'm drawing a blank here, business, what's that? Transportation, there's a host of them. Thank you, my colleague helped me out on that one. But they're not all inclusive. That's, I guess, is what the point I'm trying to make with this. There are some specific things that he's allowed to do. Again, there's nothing in there. I don't mean to keep coming back to the same issue, but there's nothing in there that says he can't advocate for veterans' rights. There's nothing that says he can't advocate for healthcare. There's nothing in there that says he can or he should or he's got a duty. That's the thing I'm trying to impart here is he's able to do these things. He's not prohibited to do it from these things. And I kind of disagree with counsel when he said that, because he's trying to characterize it that you have to have a breach of law in order for some of these ethics statutes to apply. And I've never said that. I'm just saying that there's no rule or law prohibiting him from doing these things. And he's wanting this commission to act again as the gatekeeper as to what the lieutenant governor can and cannot do. And unless you can make an argument that he can't do those things, there's no ethics violation. Furthermore, again, there's no significant personal interest here. It's not benefit him personally because he's trying to, and that's the big component that they're pushing on all these statutes. And they mentioned this about the coursework. Well, that coursework, the guy was doing his homework on company time. That's him personally, and it's personally benefiting him. This thing here is not personally benefiting. They might try to argue, well, he's going to run for re-election down the line, and this is trying to help him. That's too much speculation. That's too much trying to predict the future. And that's why the statute says what a candidate is. And I think it is important. The reason I stress the person being a candidate is because all the cases they have cited that they try to apply here, that person was in the middle of a political campaign, declared candidacy, Antonoro, Seagram. And I know Matt's in there trying to say one a candidate. They had a big recall thing going on there, which makes her the candidate by default. So those are the things I think distinguish the case law. If you've noticed from the pleadings, they haven't set forth one iota of authority on this specific issue. That's really dead on applicable for this. And I know y'all got a lot of leeway to interpret what it is, but again, you got to have some way. You got to be given something besides a conclusory citation of the statute and said he breached it. Got to have something, and they don't. Their case law doesn't support it. The statutes, you got to have all those things again, which they haven't weaved the facts into the law. And so that's about it for that topic, I think.
So, all right, so let me ask you this question. Is it your position that the lieutenant governor has a First Amendment right to use the resources of his office and of the state to support his personal interests? And what is your position based on?
So
law, statutes?
What you mentioned earlier, there's a kind of a blurring of the line between personal and his political or his office things right here. All right, so if I'm up there, let's say I'm Governor Lombardo, All right, I want this legislation done. Is that my personal? Is that my personal thing, or is that what I was elected to do? Or is that something what I feel is good for the state, or is it all the above, or some combination thereof? Because the line is blurred there. Does he have a constitutional right? The case that they were talking about Kerrigan, which I kind of misquoted, admittedly so. But that case there basically said, what it really says is you don't have a safe harbor. And what that means is you're not allowed to, to say this, and that, and then, oh, this case here, I can say anything I want. That's not what that case is saying. It's saying, you've got there, it's probably case by case basis. You got some areas there where you might get a safe harbor and other areas where you may not get a safe harbor.
I think, each of the constitutional officers, their statutes are spelled out as to what they can and what their job duties are. I mean, controller is very specific. If the controller wanted to go and form a task force about puppies and use the controller's office resources, how is that a duty of the controller's office?
The controller's probably apples and oranges here because that's the accountant for the entire state, if I'm not mistaken. And there's a lot more different duties involved when you're the accountant for the state because your financial issues and the whole 9 yards. And they're not really there to, comptrollers, I think, is not a really an illustrative example because they're not really there to advocate about other issues because their scope is so limited, I think, in certain respects. And because they're somewhat limited in certain respects, I think the comptroller, and I'm only giving personal opinion here, comptroller should be talking about how we can improve the accounting thing, how to balance budgets, et cetera, get people paid, the whole 9 yards. And I think the office, the other constitutional offices like Attorney General, Governor, Lieutenant Governor, got a big, broad spectrum of what they're doing and the way they politic, the way they get elected, the way they've what they have to answer with their constituents.
Okay, so I don't know, maybe our executive director has the answer to this question and he can answer it for me. I know that the lieutenant governor is pretty specific, okay, of their job duties and stuff. So if the executive director could tell us what the specific job duties are.
Yeah, so I'll say that the duties of the lieutenant governor are established in the Constitution and then through the legislature, primarily sitting on the different boards and commissions that we've discussed. I think tourism is one of the bigger ones, being on the transportation board, outdoor recreation. And in each of those duties, the lieutenant governor has done important and good work. But
are any of them athletic boards?
There are no boards that are athletic boards. We, as part of the record, you can see we asked many of them. We said, okay, as we're trying to figure out if this is a governmental interest or the lieutenant governor's significant personal interest, we said, okay, transportation, tourism, outdoor. Can you provide us any meeting agendas, items, reports your government entities had about children's sports? Right, which is the topic of the task force, and they had no records, right? They said, we don't have any records, we don't do any of these things. The lieutenant governor confirmed in his deposition, I haven't taken any of it to any of the boards or commissions. I said the problematic piece is where the lieutenant governor said in the Nevada Newsmakers interview, right, that he's a lieutenant governor, he'll do whatever he sees fit. Well, that's not the law, that's not how government works. He said, well, I'm supposed to go ask the legislators for permission on how to use my office. Yeah, we talked about that in our commission meeting today. That's how every 2 years you go to the legislature, you ask for funding to do things. If you want to do more things for your agency and statute, you go get that statutory change and you get the green light to go do it. And so that is why we asked those particular questions. Did you ever ask for a budgetary authority to do this? Did you ever ask for statutory authority? Because we were looking through this process, like, is there anything in here that says this is a duty of the office? And there wasn't anything in law, budget, statute, or testimony that showed that this particular topic related to the office of the lieutenant governor.
Follow up on that one. The fact that if we assume for present purposes that the lieutenant governor acted outside of his authority in creating a task force, I mean, that alone is not an ethical violation, right? And that isolated fact would not be unethical.
Right. The lieutenant governor can establish the task force. It is the use of his subordinates to do that work. It is the use of the equipment and the emails and creating the rally agendas and those types of things that creates the violation. Just creating the task force itself on its own does not. It's the use of the government resources to do so. That is the problem in this particular.
For the board of tourism, or maybe it's commission, I could be just blending them all at this point. Can you see an avenue for him to create the task force under that?
I think it would be challenging on tourism based on their, based on their scope of bringing people into the state. If there was evidence that there were, particular, I guess, sports that wanted to be in a state that had particular policies. But when you go about setting up a task force like that, then typically you continue to have meetings. You're bringing in folks to come up with some statutory change like that, which there was no, there's no evidence of. And it would be something similar, like when our commission has a specific task we want to take on, the commission votes to create it. Right, there was no vote by any of the boards to create this particular task force and handle this issue. So I don't think that there's anything in the record that shows that would be the case.
Mr. Moran? Yeah, I'm just as it comes up.
I just wanted to know from the executive director. So, but we all agree that the lieutenant governor's responsibilities would include that limited. Well, I mean, I guess it would be like limited powers, and those limited powers would be both executive powers and legislative powers because he serves as a tiebreaker in the Senate. And so that's where I'm kind of. So the idea at the end of the day is you're suggesting as it relates to these postings, he could have posted the same content, but it needed to be posted through his government account as opposed to his own personal account and not reposted.
Let me make sure I understand. So I'd say yes, the office of lieutenant governor has limited powers and authorities. Right?
Does it include those two though?
It includes the executive functions he's been given by statute, which is tourism and transportation. And then he is under the Constitution, the president of the Senate, and can break a tie-breaking vote if necessary. Lieutenant Governor Hammergren tried to use that as a reason why his conduct was allowable in the case where he sent out letterhead supporting a particular bill, and the commission rejected that as a defense to
we don't have any letters from the lieutenant governor's office on his letterhead endorsing this particular action of his, I guess.
Yes, we do. That were posted to the social media.
They're letters, but they're posts. They're not actual letters.
They're not physical paper copies that were sent because Hammergren was long ago, and now we do it digitally. So press releases, they indicated that there's press releases created with the letterhead, title of the office, state seal that defend the task force that announces.
Okay. And then one other question, if you don't mind. If the lieutenant governor had done things consistent, compatible, harmonious with the way that you feel ethics in government works for this particular commission, what would he have done, or what would you have had him do differently?
There would have been no use of state email systems or computer systems by state staff to develop the rally agendas and the 3 or 4 flyers that are mentioned in the response. So you would do it in your private capacity as an individual, not using the mechanics of your office.
So, but you don't think that that was just a function of his passion in advocating on behalf of that office in terms of with regards to those political views?
I think it was a Essentially, the way the task force came about is a lieutenant governor in a different state had a legislative task force on the topic, comes in, staff says, hey, maybe we should do this. He makes the decision, yes, let's go do it. And then the staff went about, well, there was some confusion in the staff about who was going to be responsible for that, a grant funded position in the Office of Small Business Advocacy or the chief of staff. And once they got that cleared up, the staff then executed that desire.
And then just last question, the difference between a significant pecuniary interest versus just a pecuniary interest, how does that like line up in your mind?
Yeah, so in this case, there's no, at least with regards to the task force, there's no pecuniary interest. It is prominently featured on the campaign for re-election. So it is being used in that particular way. But the significant, we've had good previous cases about what does significant mean, and it's like non-nominal, right? Like I might have, a fleeting non-significant personal interest in like tacos tonight for dinner, right? It's quick, it's done. That's a personal interest. Significant is that non-nominal, like this is something that is important to you. And we heard his own words that it was important to him, and there does not have to be a significant personal benefit, right? So an attempt to say that significant personal interest equals benefit, you don't have to show a direct benefit to yourself, just an interest in that particular topic.
I have another question. Lieutenant Governor's side here, they raised the issue of notice, and I was reading the notice, and I'd like you to address that comment, and I just want to read what the notice says. And it says, I'll just read it in full. Specifically, the additional issues and facts discovered during the jurisdictional review process include use of government social media accounts belonging to the Office of the Lieutenant Governor, the Office of Small Business Advocacy, and the Nevada Division of Tourism to amplify and promote private, non-governmental, political, and personal accounts of Anthony Johnson and others. The primary focus of the complaint allegations related to the task force is the determination about whether the task force is a personal interest or an interest of the Office of the Lieutenant Governor. So earlier, if I understood them correctly, it sounded like that it was sort of new, the piece about, the creation of the social media for personal. And so it doesn't look like it's in the notice, but how does that work?
Yeah, so the way that it works is that anybody can file an ethics complaint. And so the subject matter in the complaint is only focused on the task force. So when it says the complaint is focused on this issue, we wanted to make it clear to the Lieutenant Governor that we're not deciding whether the topic itself, right? Our concern is this question. Then there's a notice of additional facts and issues that says, in addition to what was in the complaint, here are these other items, which was the amplification and support of those private social media accounts. And then, and then that's where the demonstration, everything else that in terms of the course and scope of the investigation align with those two items.
Was the same content used on the public account or the Lieutenant Governor account as his personal account?
There are some instances, and so there are some instances where it's the same content in both spots. And then there are some instances where the official account is just amplifying the private account.
Okay, that's what I thought too. Thank you.
Well, Madam Chair, so did you hear the answer from the executive director? And
Yeah.
how are you responding to that notice, the questions that were
Okay.
like?
Glad you asked. As on April 14th, 2025, y'all issued an order right here. And here's what the order says. It says order on jurisdiction and investigation. And it says the Nevada Commission on Ethics received an ethics complaint on February 27, 2025 regarding Stavros Anthony on April 10, 2025 pursuant to the requirements of the Nevada Ethics and Government Law set forth in NRS Chapter 281A Ethics Law in parens and NAC 281A.405 The commission conducted its jurisdictional evidentiary review of the record, including the ethics complaint, supporting evidence, and the recommendation of the executive director. Then it says it is hereby ordered. The commission accepts jurisdiction of this ethics complaint and directs the executive director to investigate and serve a notice of complaint and investigation regarding the subject's alleged violation of the following provisions of the ethics law. And it says subsection 7 and subsection 2 and subsection 9 without reading them. The very next day, what is Commissioner Smith just read, the very next day they issue their notice of complaint, investigation, and notice of additional issues of fact. And that's ED Exhibit 00168, in case anybody's looking it up that way. And nowhere does it say anything other than what's dealing with the task force. And so they put other things in there they're trying to say is a violation, but it's not given to us. We heard about it really defined for us the first time they file a motion for summary judgment. And it wasn't put there before discovery started. It wasn't put there for anything because we would address that a lot more in depth as well. And so really what we're here for is one sole issue is, did he have a significant personal interest in this? There's no other issue involved here. And the way they try to get that again is because they said he's passionate about it. So really what they want you to do is they want you to be uncaring, not passionate, and just be a robot to be a public official. Because if you, God forbid, say that I have an interest in this or I'm passionate about it, are you subject to an ethics violation if you send out an email or you write a letter or you put it on your website? Hey, we got to get behind the veterans on this or something. And that's the problem that this has. There's just not enough notice on this. And they really, it takes too big of a stretch to say I'm passionate about something and then say that's a significant personal interest. And I want to stress something. It's significant personal interest. They try to make it sound like it's something more than de minimis. And it is a significant personal interest in statutory construction under the law. You have to give all the words in a statute their meaning, unless it's vague and ambiguous. And then a court is not allowed to go around the plain language of a statute. So it says significant. And the things that they were citing in there was more than just a de minimis amount of a violation by these folks. And again, probably almost all the cases had a pecuniary interest involved or something similar to them. But the cases don't apply to a situation like this that they've cited or that I could find myself. And I'm not saying I looked at every case over the last 10 years, but I couldn't find anything that applies on all fours with this type of case.
Vice Chair Long, are we done with the hearing? When are we going to have return this back to the commission so we can discuss?
Well, we would deliberate in private. Yeah, we would deliberate in private. But if people have questions, that's what we're going to be doing. I
was just hearing the arguments reiterated again.
Yeah,
and again.
I know.
So I wanted to make sure where we were at in the process.
Don't worry, I have a plane to catch tonight, so we will get out of here. I just want to ask the executive director to comment on what was just brought up.
I think the notice of complaint and the notice of additional issues and facts is clear about what we were looking at. The amplification of the social media and then the complaint itself was focused on the task force. I can tell you in this case, there was a second notice of additional facts on something that came up that we investigated and determined wasn't an issue. It didn't get past the panel in that particular one. So the whole mechanics of here's some additional facts and issues is allowed in our NAC. We don't have to handhold subjects and exactly what we're talking about. The notice is sufficient.
Other questions from you guys? Because
I don't think so.
yeah, just we talked about quite a bit, so.
If there's any more questions.
If there's no more questions, then we will go into closed session and deliberate and come back, okay?
Okay,
Thank you.
I know we might be on this real short, it might be a lot of time. Do we stay around outside here?
Yeah, well, you can stay in here. We have another room.
We're gonna leave.
Oh, okay.
Yeah.
They
Go ahead, you got.
just, both of you meet us on the deliberation link I sent. It may take us a second to get the web going, but we'll be over there. So. Up into the teams, like, one extra day of the cruise is great. Yeah, we knew we weren't getting it, and the other two were on. But everything I had, yeah, did, we your beer on. Wait. But the first.
So Mike, do we have to go to another section of the meeting?
That's what I was just trying to
Have go
figure out.
Back in?
Elvira,
You have to, join the Teams link that Liz sent.
I'll have to find it, so.
She should have
What?
emailed it to you.
I'm sorry, what are we doing?
Your meeting, through the Teams link that Liz sent separately.
We'll have to find it.
Yeah, I have to find it too. I can,
Sorry, are you able to resend it to them?
Yes, I'll resend it.
There's a lot of gear.
I'll resend it to you.
Yeah.
Okay.
so do we leave this meeting and
No, you can go into both.
Yeah,
actually.
you'll
you
leave
realize
this
how much
meeting
code
and
you
I'll send you the link.
Have 3 pairs of pants.
My father said that you and my grandfather shared with her.
Then you have under this, like.
My dad said the same thing too.
I heard people talking over each other, but I didn't understand the words.
Yeah, mine won't let me into that link.
This is effed up.
I just emailed you the link, so you'll exit there. You'll exit this meeting and join the other one.
Can't hear anything.
I don't think they've turned it on.
Good, I thought I'd lost my hearing.
But they can't hear us there. Yeah, we just had an unmuted.
We're still not
looking for,
unmuted.
Yes.
Oh, we are?
That's me. Sorry, I'll rename me.
No, but we're still muted down there.
No, that's,
That's
the
Elvira, sorry.
Oh.
That's Elvira, that's.
Oh, my bad.
And,
When it's
you can't
green.
see
I don't
us.
know how it works.
Yeah, when it's green, they can hear you. Where's the keyboard?
You know, that's. I don't have this printed out because I just don't.
You're not gonna do fingerprints.
That's part of roll call. Welcome back. All right.
Oh, we throw back on the record.
Are we back?
Back on the record.
Okay, great, all right.
It's 3:12 PM. We're back on the record.
All right, thank you. All right, at this time, the commission has deliberated and we have reached a decision. After we vote on our decision, then the next step will be to have each party.
Well, first you gotta.
Do willfulness.
Well,
So I'm just doing the steps, okay? So that's the process, all right? So the motion is, the commission has reviewed the entire record for this matter and has considered the pending motions and arguments of council. I move to grant partial summary judgment in favor of the executive director with respect to the claims of one violation of NRS 281A 400 subsection 2 and 2 violations of NRS 281A 400 subsection 7, and to grant summary judgment in favor of the Lieutenant Governor Anthony with respect to the claims of violations NRS 281A 409.
Is there a second to that motion?
I'll second that motion.
Okay.
Any comments or
Yes,
discussion?
It's not my first rodeo.
I know, I just want to make sure we're doing it correctly.
All right, are there any other comments from the commissioners? Okay. Before we vote? Before we vote, yeah. All right, hearing none, I'll call for the question. All those in, we're gonna do a roll call vote. I think it would be good. All those in favor, we will start with, I'll start with up there. Commissioner Langton,
Yes.
Commissioner Reynolds,
Yes.
Commissioner Moran,
No.
Commissioner Smith. No. Commissioner Wallen, yes. Motion carried. Council for the commission is directed to prepare an order in coordination with the vice chair to reflect the determination of the commission. Next, we will hear from respective councils to talk about willfulness. You will have 5 minutes. And after they discuss, then we will have some comments, and then we'll go back, deliberate, and come back.
Can I just ask for some clarification? I want to make sure I had it correct. Is the basis of the violations the social media or the task force? Or, but just because.
I think our understanding was that you were requesting in your motion one violation of 407 for each of those.
Yep.
And that is what was granted.
Okay.
And then 402 was just the one violation, as we understood it,
For the
social media.
social media. Okay. And then none of that.
None of them.
Got it. Okay.
All right. And we are.
Thank you. This is Executive Director Armstrong. I previously submitted a brief on willfulness, and so I just want to briefly touch on that. To the extent that there are violations related to the task force, I believe those violations should be non-willful based on the limited nature of the use of equipment for that. And there were some aggravating factors in previous cases where we found local violations where staff were bullied or required to do things. In this case, there was no evidence of that. Staff was on board with this mission and direction. And as we had in some testimony, you know, on one, she did a lot. That's one of the things she did. So when it comes to the task force violations, I recommend that those be found as non-willful. But when it comes to the social media violations, I believe there should be one willful violation for one. Of the factors that the commission considers when making the willfulness determination, you know, there's a mitigating factors. Has there been any correction, self-correction? And in this case, you know, the review panel recommended a deferral agreement where we could mitigate these issues and get them cleaned up. That was rejected. And in reviewing the conduct of the office, while this case has been pending, there have still been issues regarding social media. Some of that has come from new staff, but it's clear that trying to figure out what to do in these cases has not been a priority of the Lieutenant Governor's office. So I think one of the violations should be willful. In terms of the remedies, the commission is tasked with taking any combination of acts to address the issue and to deter similar future actions. I believe that a $3,000 civil penalty is appropriate in this case. A formal reprimand by the commission, which is not a censure. A censure finds that there's wanton disregard for the law, but a reprimand is appropriate if there's a willful violation. If there's no, and then they also order ethics training for Anthony and his team so that they can be aware of the ethics law, and a requirement that his office adopt a social media policy. I'll tell you in terms of the mechanics of the law, if you do not find that one of the violations is willful, there would not be the legal ability to do a civil violation, and the reprimand would have to be dropped to an admonition. So that is my recommendation in this case. I think only a civil penalty will help the Lieutenant Governor understand that there are these rules that he needs to be following in the course of his conduct. But I also, in terms of, you know, there's others that I think are non-willful. He has a long service to the state without ethics violations. He's shown previous willingness to go get advice. And so that is why, like, I would say less than Augustine, less than a Matson, who had multiple willful violations, that a single willful violation, with the others being non-willful in this case.
Okay, thank you.
Thank you. Just want to clarify something on the violations that he is found to have violated. Were they all involving the task force or social media posts that were unrelated to the task force?
The ones for 2 and 7 were social media. And on 7, it's also for the task force.
Okay, so the 2 that we found violations were unrelated to the task force. I mean,
No, we had, no, there's one violation of 402 for amplification and use of staff for the amplification of the private campaign account. One violation of NRS 281A 407 for use of staff time and social media accounts and letterhead in promoting his personal interests. And then one violation of 407 for using state email systems and government social media accounts, letterhead for the task force.
okay, so as I understand it, the director is not seeking a will for on anything related to the task force. Am I correct on that?
Correct.
So we're addressing the other 2 for the use of the social media. And that's how I'll direct my comments then. You've heard hours and hours, yes, a long hearing here about whether this was a violation of the ethics law or not. I think a lot of us can agree that this was kind of a gray area here. And that given that it was, you saw that there was no pecuniary interest, there was no personal commitment of personal commitment or someone to a personal commitment in this. And it was very de minimis, actually. It's just using some emails. It was using some staff to do some of these things. Now, under NRS 281A170, it says a willful violation means a violation where the public officer or employee acted intentionally or knowingly. And I can tell you, you know, just obvious can hear from all the arguments that this wasn't done intentionally and knowingly. Or 2 was in a situation where this chapter imposed a duty to act in the public officer employee intentionally and knowingly failed to act in the manner required by this chapter. Again, you heard all the arguments. Doesn't appear that there was anything in here that was intentionally or knowingly. And this wasn't a campaign account. And then it says, unless the commission determines after applying the factors set forth in 2A1775, and these factors, there's several of them. One is the seriousness of the violation or the alleged violation, including without limitation, nature, circumstances, and extent and gravity of it. Again, I don't want to revisit every argument that we put forward in here. This, in the grand scheme of things, this was really not a serious violation. I don't think anybody can say it is, because you're using, you had a few cases of social media. You had a little bit of the staff. The evidence in this is not during the hearing today, but in the moving papers. Very diminished amount of time. He said just we got it formed and that was it. That was the last we were doing with it. And they were advising me there was no public funds expended on it or anything. So the nature of this, although it's an important issue, but the seriousness on the grand scale of things, especially compared to the other things that occurred in the case law. The second one is the number and history of previous warnings. There were none. There were no previous warnings on this. We did get after the complaint was filed, we got the offer to settle, but that offer to settle didn't include anything about amplification of media and everything else. So even if we had taken that deal with that, we would have probably been back here possibly on their application of media. Who knows? I don't know what the intents are on this. But we have had no previous warnings on this, nor have we got any previous violations. The cost to conduct the investigation, any meetings, hearings, or other proceedings related to this, I do know that the cost was really low from the perspective of the state. I have no way of knowing 100%, but I do know they took 2 depositions right here. I think those depositions lasted less than 20 minutes, and they weren't very extensive. I'm told, I took the deposition of Mr. Terry, and he wouldn't say what he did, but all I could do is assume that he talked to several folks on Mr. Anthony's staff. So there wasn't a huge cost on this. There was some briefings going back and forth, but that's the job of the director in the first place. Any mitigating factors? We fought this. I just got to tell you, we fought it, which is our right. I can't say that that we've rolled over on this by any stretch, and nor do we intend to. And but we will take under advisement everything that's being said. My clients will make the corrections as necessary. The other thing is any restitution or reimbursement paid to parties affected by the violation. There is none, so that factor doesn't factor in. The extent of any, this is F, the extent of any financial gain resulting from the violation or alleged violation, there's none. There's been no allegation. So with this said, it's clearly, this is something that Mr. Anthony said that he was very passionate about, thought he could do it under the powers of his lieutenant governor's office. And with that said, I would ask that you find non-willful on all the charges of which you found him guilty of.
Almost on the button of your time.
Yeah, thank you.
Let's have a good internal clock.
Oh, shoot, that's all those appeals, you got that.
Yeah, questions.
Madam Chair, I just had a quick question. So, and it might be for the executive director or commission counsel. So when does the actual decision attach? Is that after the notices go out, or is that after the vote this morning as it related to the liability?
That's an interesting question. I don't think it's effective until we issue an opinion, but the decision's been made, but there's nothing appealable until we issue our opinion.
And
So
when do we anticipate that being issued? Like typically, what's the standard operating course for that?
well, this will be the first one I've done here. So I'm on vacation next week. I'll be honest about that for spring break for my son. And they'll have to go back and everyone will get a chance to look at it. So I'd anticipate a couple of weeks.
And so the only reason I say that is there may be an opportunity to maybe still resolve this. I don't know if that's something that you may want to think about because the vote was very, very close. But there may be an opportunity because I understand that there was a deferral agreement that was extended as some sort of a settlement negotiation. And I thought that was a very, very fair offer. It sounded like you were concerned they did not take into consideration the additional charges. And see, I was under the impression that it took into consideration all the charges. So that was for me, I kind of thought that, because again, it's kind of like a not guilty plea, guys, when you're in there and they stay in adjudication, and if you complete this, and that, they dismiss the charges, same thing. And you look at the guy who's sitting there, the defendant saying, well, I just want my day in court. And the prosecutor's looking over and saying, well, at the end of the day, you do these little things here and you're gonna get the same thing, and you may get convicted. So I didn't know if that was, I don't know if that's something that would be irregular. You've been doing this longer than.
Yeah, I mean, I think it would be irregular because the commission has voted. I think certainly even after a decision is made, if the parties want to reach an agreement between themselves, but that would have to be between the parties.
The executive director and. Okay.
Yeah.
So that might
but
be
I think,
something
you know,
that
the
may
vote
wanna
has been made. There's not a lot of impetus for the executive director to, I mean, you know, at this
No, I
point.
understand.
Yeah. But yeah, so a deferral agreement would always cover every violation that has been raised in that notice and order. Like, of course, they cover all of it.
So like I would say, you know, Mr. Blangus, it might make sense to at least take a shot at the executive director, because this commission does a legal shot, an ethical legal shot. But I think that there's an opportunity maybe to resolve this to your satisfaction as well, because you know, a deferral agreement is like one of the best agreements, plus continued education, and as the political proponent, which would be Mr. Anthony, you'd think that he would want to take that continued education, because continued education is going to work positively for everyone. And the stuff that we're putting out, whether it was the governor's office and other different, you know, political offices, they've all been very receptive to that education. And so maybe that's something that you might want.
Vice Chair Wallen, can we go through and we could, that's an item for later. Can we go through and determine willful or non-willful on these items?
Well, we're gonna, we have to deliberate in private for a second.
Deliberations.
Okay.
I just want to ask you a question.
Sure.
I've never heard of us doing a deferral agreement without all the stuff in it. So the deferral agreement that the review panel passed, did it not have the social media?
No, when a review panel recommends a deferral agreement, that closes that full complaint. Anything.
Okay.
They don't, when you are on a review panel, you don't get to issue like a partial deferral agreement and a partial go forward type of thing. It would include it.
Okay, that's why I was very confused, because I've never heard that we had never did deferrals on just part of the case, so, okay. So obviously.
May I
Yes.
ask
Yes.
Director Armstrong a question?
Yes.
You recommend that there be an adoption of a social media policy. My question is how will that be monitored, if at all? And will it be a policy that must meet and comply with ethics laws?
Yeah, this is Executive Director Armstrong. It would, in order for him to comply, if you were to adopt that, you can put in the language about what it has to include. I would imagine it would include non-amplifying private social media, using the government social media, and requirements for staff, and creating content for private social media. Compliance on any agreement. For example, if there's a fine or anything, that all falls on the executive director. When someone at the end of a case has complied, I send a memo to Liz that says this person has complied, this case can be closed. So one of my duties as the executive director is to monitor compliance with any cases that have a final decision.
Okay, thank you. I have a question now for Mr. Flangus, if I may.
Yes, please. Go ahead.
Okay. I've heard your argument about de minimis. Are you arguing that de minimis is no violation?
I argued that previously, yes, sir, that de minimis, because on a significant personal interest, as I said, the word significant is in the statute. You got to give that its due. So some of the de minimis would not be would be a violation because on a, you know, when we're talking about de minimis, I was talking about it in the context of a significant personal interest. And the arguments were made by the director that you could find a significant violation on a significant personal interest on a de minimis type of behavior or action on their part. And I countered that and said, no, the case law is a little bit more extensive on that. And it's more than de minimis for a significant personal interest to attach to find that the person violated the statutes.
Okay, thank you.
I hope that didn't sound too much like a word salad, but hopefully it got your question answered.
I did.
Anything further? No. Right, then we will take a break and deliberate and we'll be back.
Liz, is there any possibility we can stay on this one? Oh, it's recorded, so we have to go to a private one.
Right, I'm sorry, that's why.
Oh, okay. Okay, I'll try to find it again.
But you're doing a good job.
What's that?
You're doing a good job. You keep finding us.
Okay. All right.
Yeah.
Hasta la bye-bye. Well, Terry, you and I are here. Where are they?
Looks like we're getting back on.
Right on time. As soon as I mentioned it. Hmm. Hmm.
Are you ready to be on the record? Yes, it's 3:56 p.m. We are back on the record.
I think bang it or not. Ready?
Back on the record.
Right. We have reconvened and the commission is ready to go and make their determination. The commission has considered the record and the parties' briefs and arguments regarding the willfulness of Lieutenant Governor Anthony's violations of the ethics law and any penalties that should be assessed. I move to find that Lieutenant Governor Anthony's violation of NRS 281A.400 subsection 2 for the amplification of his private social media accounts using the official Lieutenant Governor's official account is non-willful. That his violation of NRS 281A.400 subsection 7 for the use of state time, government social media accounts, letterhead and seal in support of private social media is willful, and it is violation of NRS 281A.400 subsection 7 for the use of state email systems, government social media accounts, letterhead and seal in support of his private interest is non-willful. I further move to impose a civil penalty in the amount of $3,000 for Lieutenant Governor Anthony's one willful violation of NRS 281A.400 subsection 7. Require that the Lieutenant Governor obtain ethics training within 60 days of the Commission's opinion in this matter, and require the Lieutenant Governor's office to develop a social media policy. I further move to admonish the Lieutenant Governor for his actions in violation of the ethics law. Counsel for the Commission is directed to prepare an order in coordination with the Vice Chair to reflect the determination of the Commission. Is there a second?
Second.
All right, any discussion? We'll do a roll call vote. Commissioner Reynolds,
Aye.
Commissioner Langton,
Aye.
Commissioner Moran,
No.
Commissioner Smith,
No.
Commissioner Wallen, yes. Motion carried.
We have a few more items on our.
And we have a few more items. Next item is commissioner comments. Are there any items?
Well, that, we close that item.
Oh, this item is closed, so sorry.
I want to make sure you guys can be closed. We have more to
Much
do.
as I'd like to stay here. and
I know, especially if
You
you'd
know,
like to
it's
be
just
part of
nice
our
to
comment.
spend the day here.
Thank you all.
Very
Thank
much.
you.
Nice to see you again, Kim. It's been a long time.
You too, I know.
I wonder if it's the same one that I knew from way back though. See you later.
Take care.
Next item is commissioners' comments. Are there any items that the commissioners would like to put on a future agenda?
I have one question related to the procedure, because this is my first due role. Right, so for my staying hearing. Will there be an opportunity to provide a dissent after the decision, like that people have done in the past?
Yes, because this is an opinion, particularly that parties, commissioners can dissent because it's an opinion.
So there'll be like a period of time, so you'll
Yes.
email us like usual.
Right, I will consult with you, yeah.
Sounds good.
Yes, there will be. Any other commissioner comments?
No.
No.
I just want to thank the commissioners for their participation today and all of their hard work in this and being so well prepared. And I want to thank the staff for doing a great job here. I can remember this part. Yeah. Okay. All right, so that's no other comments. Next item is public comment. Commissioner or Executive Director Armstrong, have you received any public comment by email to be read into the record?
We have not received any public comment.
Okay, are there any members of the public here?
Members of the public here, they have not indicated they would like to.
Okay, and do we have anyone on Zoom that would like to make public comment?
Elvira Saldana, for the record, there is no members of the public on Zoom.
Okay, right, with that, I will entertain a motion to adjourn.
I so move.
Is there a second?
I'll second.
All right, all those in favor say aye.
Aye.
All right, motion carried. We're adjourned. Thank you all.